Very good.
Good morning. All right. I think everybody who, let me just double check and make sure no one's in the waiting room here. All right. It looks like everybody who wants to appear this morning has been able to log in. So we will go ahead and get started. First of all, good morning. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office, and I will be presiding over the hearing today. This is a hearing on the draft cease and desist order that was issued by the State Water Resources Control Board Prosecution Team against BlueTriton Brands, Inc., which was formerly known as Nestle Waters North America, Inc. And for shorthand, I will refer to that entity as BlueTriton today. Besides me, the people from my staff who are participating in this hearing are Nicole Mullen and Amy Blunk, Kyle Woldridge, and Skylar Anderson. As discussed in, sorry if I'm looking down at my notes here, I'll try to look up. As discussed in section 12 on pages 21 to 22 of the November 17 notice of second pre-hearing conference and hearing, the Administrative Hearings Office, which I will refer to as AHO, has not ordered a court reporter for this hearing. My understanding is that BlueTriton has ordered a court reporter, Francine Dias, from Imagine Reporting. For an earlier pre-hearing conference, I asked BlueTriton's attorneys to send the AHO the court reporter's contact information, and I request Mr. Donlin, if you can do that again, just send an email to the AHO email address with CC Stereo on the service list. And we also then will post the court reporter's contact information in the AHO FTP folder for this hearing when we receive it. If BlueTriton or anyone else files a transcript prepared by the court reporter with the AHO, then we will add it to the public administrative record. Whether or not such a transcript is filed, the audio plus video Zoom recording that we are preparing for this hearing will be the official record of this hearing. And therefore, in any briefs, particularly closing briefs, but any other briefs, I ask that you cite to the date, hour, minute, and second in the Zoom recording if you need to cite to the hearing process. For this hearing, I will call on people to speak. If you have something to say and I have not called on you, please let me know by raising your hand, either the old-fashioned way or electronically. I do try to keep an eye on the hands that come up electronically as well. And if you have to, you can just speak up. I realize it's not as easy to do that as if we were in person, but we will proceed that way. Please do keep your microphones on mute, and I see that you've all done that. When you are not speaking, that eliminates the problems that otherwise can come from feedback. I ask that you address me as Mr. Lilly, and I will refer to each of you as Mr. or Ms. with your last name. This is not a court proceeding, so you do not need to say Your Honor, but I do want to use Mr. and Ms. when we're referring to each other or addressing each other to keep the proceeding somewhat formal. So please try to avoid calling anyone or referring to anyone by their first names. Using the notices of intent to appear that have been filed, I have prepared a list of the people and parties that it is my understanding will be participating as parties in the hearing today. When I call your name, please let me know if you are appearing on behalf of yourself or if you are representing a party, the party's name. And for parties with more than one attorney should state his or her name and then the names of the other attorneys and party representatives who are participating. Let's go a little faster. Okay, so I'll go down the list, starting with the Division of Water Rights Prosecution Team. Mr. Petrozelli, go ahead.
This is Kenneth Petrozelli, appearing for the Division of Water Rights Prosecution Team. Mr. John Prager,
another attorney will be assisting me this morning.
Okay, and why don't you just go ahead and identify your witnesses who are on the call this morning as well?
Our witnesses who are on the call this morning are Tomas Eggers, Victor Vasquez, and Natalie Stork.
All right, and good morning to all of you. Thank you. All right, so for BlueTriton, Mr. Donlin, please enter your appearance and those of your colleagues.
Good morning, Mr. Lilly, and Happy New Year. Robert Donlin for BlueTriton. Joining me today as co-counsel are Rita McGuire, Chris Sanders, and Shonda Grady. All
right, and why don't you identify your witness? If you, I don't see Mr. Lawrence, he may be on page 2 here. Do you have witnesses who are, or other participants for BlueTriton who are here this morning?
Yes, the only witness that may appear is Larry Lawrence, an employee of BlueTriton. Okay,
oh, there he is. Okay, I see Mr. Lawrence has a tile here, but no video yet, and that's fine. All right, thank you. So for California Department of Fish and Wildlife, Ms. Murray.
Hello, Mr. Lilly, Nancy Murray and Kathleen Miller will be also representing CDFW in this proceeding.
All right, and just to confirm, Ms. Murray, we did not receive any exhibits from CDFW, is that correct?
Right, we're here to cross-examine if as necessary.
All right, and that certainly is your right. So I just wanted to make sure we hadn't missed any exhibits.
No, thank you.
All right, thank you, and good morning. So for San Bernardino Valley Municipal Water District, Ms. Nickel, please go ahead.
Yes, good morning. Meredith Nickel on behalf of the San Bernardino Valley Municipal Water District. My colleague Sam Bivens will also be participating in the hearing.
All right, good morning to both of you. Story of the Stuff project, Ms. Doty.
Good morning, Rachel Doty on behalf of Story of Stuff. Jessica Taylor will also be participating, another attorney from Greenfire, and our witness Steve Lowe is present, and I anticipate that Amanda Fry will be present shortly.
All right, thank you. So I take it Mr. Kibble and Mr. O'Heaney will not be participating today.
Mr. O'Heaney is present. I don't expect him to participate.
Oh, okay. All right, thank you. All right. And then Mr. Lowe, and we did have you previously listed for the Southern California Native Fish Fauna Working Group, but please enter your appearance this morning. You have to just go off mute. If your computer will let you, there you go.
Can you hear me?
Yes.
Okay, Steve Lowe, just representing myself.
All right. Thank you. Good morning, Mr. Lowe. And so I'm going to cross out Southern California Native Fishery Fauna Working Group. I think you had that before, but I will list you as appearing for yourself. And then also, I believe Ms. Doty said you will be a witness for Story of the Stuff project. And that's fine to do both.
Yes,
right.
let me just clarify. The Southern California Native Freshwater Fauna Group has actually now turned into a Facebook page where we share all of our information through that. And so there's no longer a group that meets in person called the Southern California Group. So that, just to clarify that, I was chosen by that group to represent them in this whole proceeding way back in 2014. And I've continued to do that. But now I need to say I'm representing myself. Thank you.
Thank you for the clarification. And then for the Sierra Club, I'm looking for Mr. Silver. Mr. Silver, are you here? I don't see you.
Yes, I'm here.
Oh, there you are. I'm sorry, up at the top. Sorry, I have about 30 tiles here. So go ahead. Excuse me.
Yes, I'm appearing for Sierra Club. And Lisa
and
Malenke is appearing for the Center for Biological Diversity.
Okay, yes. Okay, thank you. And just to confirm, the Sierra Club did not submit any exhibits for this hearing. Is that correct?
That's correct.
All right, thank you. And then for Center for Biological Diversity, Ms. Malenke.
Yes, good morning. Somehow my internet dropped a few minutes ago, but it's back. I'm appearing for the Center for Biological Diversity, and we did not submit any exhibits, but reserve the right to cross-examine, etc. Thank you.
All right, thank you. And I had previously in your notice of intent to appear, you'd listed Ross Middlemas. Is he here today?
I don't believe he's here today, and he most likely will not be at the hearings, but he may be able to join part of the time.
Thank you. And that's certainly fine. All right, for Save Our Forest Association, Mr. Bilecki.
Yes, good morning, Mr. Lilly. This is Hugh Bilecki for the Save Our Forest Association.
Great, good morning. And then for Amanda Fry, appearing on behalf of herself, I don't know if she's here yet.
Yes.
Oh, there
I'm
you
here
are.
this morning. Yeah. Hi,
Sorry,
good
I've got to flip between two screens here. Good morning, Ms. Fry. Please go ahead and enter your
Good morning.
appearance.
Amanda Fry. I be appearing on behalf of myself as a citizen of the United States and a resident of California.
All right, thank you and good morning. And then, okay, I see Mr. Ohini has appeared as well. So good morning, Mr. Ohini. Have I missed, I've kind of went through that quickly, although we've all been on a few pre-hearing conferences before, so I think we know each other, at least virtually. Is there anybody I have missed who is going to participate in the hearing today? All right, and then just so we're clear on the record, we did receive NOIs from 6 entities saying that they were going to submit policy statements and may or may not participate or may or may not offer oral policy statements. We certainly have their written policy statements in the record already, and we'll consider those. But those are California Water Association, Northern California Water Association, Association of California Water Agencies, League of Women Voters in the San Bernardino area, Mary Ann Dickinson, and Henry Fry. So those of you, I noticed at least Miss Dickinson I see. I don't know if I see anybody else in that list, but at the appropriate time when we get started, I will ask if anyone wants to give an oral policy statement, and you certainly may do so at that time. We have received over 25 other letters and emails to make general arguments about the hearing, and we are treating all of those letters and emails as policy statements and have filed them in a folder titled Policy Statements, which is in the administrative record. And then we also did receive an email from an attorney for the United States Department of Agriculture and Forest Service asking that he and 2 members of the staff of the San Bernardino National Forest be included in the service list, even though the National Forest and Department of Agriculture will not be appearing as parties, and we have done that. So I have several preliminary matters I would like to go over this morning before we get started with the hearing. I'm going to just go down my list, but go ahead. Excuse me.
Ms. Starbuck has raised her hand a couple of times.
Oh, and I'm sorry. I apologize. Thank you, Ms. Stiles. Ms. Starbuck, what? I'm sorry I missed you. Please go ahead. If you can go off mute.
Yeah, I was just
there. You are. Okay.
Just identifying myself is all. Good morning.
Okay, and are you appearing on behalf of anyone else or just yourself or?
No, just the League of Women Voters of the San Bernardino area.
Okay, and at the appropriate time, I can call on you, and if you want to, you can give the oral policy statement.
Thank you.
Thank you, and I'm sorry I missed you, and thank you for Ms. Dias for pointing that out. As I say, I have to click, I can't fit you all on one screen because I only have 25 tiles, so I have to, and I think we have about a little over 30 people. So if I miss you, please speak up, but thank you very much. All right. So the preliminary matters I want to talk about this morning, first of all, regarding the site visit, we received an email, I believe it was last week or the week before, from Mr. Taylor of the Forest Service, which forwarded a newspaper article about a slide that had closed Highway 18, the Rim of the World Highway, between San Bernardino and Barclay Plumbing parking lot, where we are planning to stop for the first day. It looks like there is an alternate route through Running Springs, somewhat longer, but I think we can still go that way. So if that washout has not been reopened, we will plan to go that way, perhaps making a little later start time so we can go ahead. Mr. Bilecki, go ahead.
Thank you, Mr. Lilly. I was on the phone this morning with the owner of Barclay Plumbing, Lyle Barclay, who lives across from the turnout area. He advised me that the area is free of any snow currently. I also got a return email from Lewis Murray, who is the mountain representative for our supervisor, Janice Rutherford, and who advised me that Caltrans currently has an escorted one-lane back and forth on Highway 18, which is open and working well. I did get the number of the current Caltrans public affairs officer, who I will call later today. But right now, Highway 18 is open on an escorted basis 24/7.
All right, thank you for that update. And that certainly bodes well for January 26th, which is a little over 2 weeks from now. I know Caltrans has been working hard on that. So, Mr. Bielecki, maybe like by the end of next week, you could just send an email to the AHO, of course, with CCs to everyone on the service list, advising about the current status. And then people will know basically which way to go to get to the plumbing lot. And I appreciate your contact with Mr. Barkley for that. I hope we won't take up too much space. In this business, we never say it's good that there's not snow, but it will make the logistics a little easier for us. So thank you for that update.
All right, I'll continue to pass on current information.
Yes, yes. And as I said before, just if you can, just make sure to CC everyone on the service list, and then everyone will be informed the same way. So thank you. On January 7th, I sent a letter to the representatives of the San Manuel Tribe of Mission Indians, which I then forwarded to everyone on the service list. And that was asking for permission for us to go on the tribe's lands on the afternoon, during the afternoon of the second day of the site visit. And I will let you know when we receive a response from the tribe. But at this point, we certainly still plan to proceed with that with the afternoon of the second day of the site visit, assuming, of course, that the tribe gives us that authorization. If they do not, we'll have to decide how to proceed about that. So on the site visit, Mr. Donlin or Mr. Lawrence, do you or anyone else from the BlueTriton have any updates regarding the helicopter logistics for the morning of the second day of the site visit that we talked about to get to the area of boreholes 10, 11, and 12?
Mr. Lilly, I would just tell you that we've prepared everything as in accordance with the plan that we put together, and that weather will be the deciding factor as we get closer to the date. But right now, everything's a go.
All right, thank you, Mr. Lawrence. And we absolutely will defer to weather if we need to. That's right. Safety is our number one priority, of course. So, but thank you. All right, so as soon as I have more information, particularly hopefully a response from the tribe, and the State Water Resources Control Board's tribal liaison has been in communication with them directly. So that should help facilitate that process. But I certainly will let you all know as soon as I know more about that. But at least for right now, weather permitting, we're still planning to go forward. Of course, if we have a forecast for inclement weather on those days, we will reschedule. As much as I love to go out and walk in the rain, it'd probably be hard to do the site visit very effectively. Second, anything else on the site visit for now? And I know we've talked about it a lot and we may need to talk about it further, but just anything else on that before I go forward? All right, hearing none, I'm going to go forward. Next thing, the prosecution team filed a motion to quash BlueTriton's subpoena ducis tecum. And I'm still working on a ruling on that motion. I have gotten involved with quite a few other things that have come up preparing for this hearing. So I will get that ruling out as soon as I can, but it's probably not going to be this week because I'm going to be occupied with this hearing this week. But in the meantime, the stay I previously issued of the prosecution team's obligation to respond to that subpoena remains in effect. Next matter, BlueTriton had requested identification of members of the prosecution team and the hearing team. And per my request, Mr. Donlin confirmed that with a letter to Mr. Petrozelli and me on December 17th. And that letter also made some legal arguments. Mr. Petrozelli responded on December 21st with a letter that described the members of the prosecution team. And then I responded with a letter on January 7th to all of you which described the members of the hearing team and responded to BlueTriton's arguments. So, Mr. Donlin, I'll start with you. Do you have any questions or comments regarding these letters?
No, thank you, Mr. Lilly. We do appreciate your clarification in response to our request. We appreciate Mr. Petrozelli identifying the prosecution team. We respectfully disagree, but we appreciate that this is probably an issue that goes beyond this proceeding, and would suggest that at some point the State Water Board, the public, and the hearing office coordinate the proper communication protocols between the hearing office and the Division of Water Rights and Office of Chief Counsel for these types of hearings. In our view, the hearings conducted under, I believe it's Water Code Section 1112A are different than referral hearings under Water Code Section 1112C. And we agree with your assessment of the need for communications under proceedings conducted under 1112C. We think that more formal ex parte rules should apply with respect to proceedings conducted under 1112A. But we do appreciate your ruling on this matter, and we'll note our objection on the record.
All right. Well, Mr. Donlin, I don't believe that your prior letter made any distinction between hearings under subdivision A and hearings under subdivision C. So if you believe that there is such a distinction, and that's something that I should consider, then I request or recommend that you file a follow-up letter to me, send a follow-up letter to me, or motion, however you want to do that, of course, with CC's list. We respond. I mean, at this point, I'll just tell you, we've had no communications with anyone outside of the Administrative Hearings Office, except as necessary to prepare my letter, which of course I had to talk to people to make sure I had the right people. But we had not had any substantive discussions about this hearing yet with anybody else. So if there's some other arguments that you believe are relevant here, I'd like to receive them, because obviously this is a chance where we can address that issue before any such communications have occurred. So I'm not going to put a particular deadline on that, but I do recommend that if you believe there are additional arguments and points that need to be addressed, that you send that letter to me as soon as you can.
We'll do that, Mr. Lilly. Again, we appreciate your clarification. Are you getting feedback?
I'm not. You sound fine. I can hear you fine. I'm just drinking water. That's why I reached over.
Oh no, I was getting some weird sounds off of my computer. We will follow up as you proposed, Mr. Lilly. Thank you.
All right. Thank you. All right. The next matter on my list, and I'm sorry to have to take this time, but this is the time when we're all together. So I think it's useful. On January 7th, Skylar Anderson from my office prepared and circulated a memorandum to all parties that describes what my colleagues, he and our colleagues in the AHO did to organize a number of various parties' exhibits that did not comply with the requirements in the hearing notice. And just so we're clear, all we did was renumber and in some cases prepare exhibit lists. We certainly did not change any of the documents themselves other than their labels. And I just want to say, we just like to have every document numbered as an exhibit because it makes it a lot easier to refer to them both during the hearing and then in follow-up briefing, and of course in the proposed order we prepare. So that's why we did that. I know from my experience when I started out appearing at Water Board hearings, it's a little counterintuitive to label written proposed testimony as exhibits, but that's why we do that. It's simply a labeling thing. I certainly understand that testimony is otherwise different than exhibits, but that's why we numbered some of the parties' written proposed testimony that had not been numbered as exhibits. That's why we gave them exhibit numbers. So does anybody have any questions or comments about Mr. Anderson's memorandum or what we've done to label these documents? And I'm looking for hands, but I don't see any, so we'll go ahead then. Next thing, supplemental exhibits. This is another question for you, Mr. Donlin. My December 8th ruling granted your request for leave to file supplemental documents, basically exhibits, in response to any new PT exhibits that you contended were things that you had not received before, and specified a December 30 deadline for such filings. And I'm not aware, I don't think we've received any such supplemental filing from BlueTriton, but did BlueTriton make such a filing?
No, Mr. Lilly. We did review the prosecution's exhibits and testimony. We did not modify our notice of intent or seek to add exhibits to our direct case in response to that.
All right, and that was certainly optional on your behalf. I just wanted to make sure that you hadn't filed something that somehow got lost. We have received a lot of papers in this matter. All right, next. On Friday afternoon, I received a motion in limine from BlueTriton. I had previously received earlier that day a letter from Mr. Donlin discussing the motion in limine. And of course, he did serve that on everyone on the service list as well. I did see that this morning, Ms. Doty filed an opposition to that motion in limine, which I only had a chance to look at very briefly, and I certainly will read in more detail. And I think, Ms. Doty, the way I'm going to proceed today will preserve your rights and address your arguments. But as I go forward, if you need to say anything about that or raise any issues, please go ahead. So let me split this up into 4 parts. The first part of BlueTriton's motion in limine asked me not to accept into evidence of various documents that BlueTriton contends are not relevant to this hearing, and lists various exhibits. And I'm going to tell you how I'm going to rule. Excuse me, Mr. Lowe, I'll get to you in just a minute. I do see your hand. I'm going to tell you how I'm going to rule, and then I'll ask for comments and see if that changes my mind. And my plan is not to rule on this part of this motion now. I think it's premature. I mean, I understand, Mr. Donlin, you wanted to make your record on this and get your objection in the record, and that's fine. But it's going to be a lot easier for me to consider whether exhibits are relevant or not when the witness who is testifying about the exhibits testifies and I have that context. So the way I plan to proceed is the way we normally do in hearings like that, and that is each party may present his, her, or its case in chief with its witnesses, and then offer its exhibits. And of course, we have cross-examination, redirect, recross, and so forth. And then at the end of the questioning, that's when the party can offer the exhibits. Other parties may object, and I will rule on the objections. But I'll just say, I'm going to be in a much better position to rule fairly and accurately on objections at that point, rather than right now up front. So that's how I planned to proceed on that issue. So I'll start with you, Mr. Donlin, since it was your motion. Do you have any comments on that proposed ruling?
Yes, Mr. Lilly, I'm going to invite my colleague, Shonda Grady, to respond to your offer to argue.
All right, please, Ms. Grady, go ahead.
Thank you, Mr. Lilly. With respect to some of the documents, the issue as far as relevance was that there was no testimony related to the documents presented. In particular, Ms. Doty's list of exhibits, she provided a declaration that offered nothing more than just a source for categories of documents and no testimony or explanation as to support those documents. So the relevance of those was just simply not provided.
Well, wait, just
so in bringing the motion, we sought to just streamline some of the steps in this proceeding. We certainly, as noted in the motion, preserve our right to raise such objections as the matter proceeds. but sought to resolve some of these issues up front just to make it a little easier for all participants involved and to save resources of the parties, the participants, and your office.
All right. Well, thank you, Ms. Grady. So, Ms. Stody and the others, you certainly have received now those motions, and you're aware of the arguments they will make. As I say, though, I'm just not in a position to rule on that now. I want to have the parties' whole package of exhibits and that party's witnesses' testimony before making that decision. So your objections are noted, and I'm not granting I'm not sustaining or overruling them at this point. I'm not ruling on them, but we will consider those when we get to each party. So Ms. Doty, go ahead.
To head off any potential delay going forward, and I apologize, I haven't been part of a proceeding, this water board proceeding like this before. So out of an abundance of caution, we provided additional information regarding the relevance of the documents. However, it's inaccurate to state that there was nothing in my declaration that stated the relevance of the documents. There's a description of the document, and many of them are evident what their relevance is. For example, the Del Rosa judgment. But given that there's only 45 minutes of time to testify and the large number of documents on the part of each party and the large number of documents that the prosecution team as well as our team have proposed, I'm trying to understand how documents will be admitted into evidence, and if it's not possible that they would be admitted on the papers. And if there is some challenge to relevance, if we'll be given an opportunity to make an offer of proof.
All right. Well, thank you, Ms. Doty. And just so we're clear, the 45 minutes is really just to summarize written testimony. There was no limitation on the length of written testimony. So all parties did have full opportunities to provide written testimony to authenticate all of their exhibits and to demonstrate their relevance. So I don't think that's a proper objection. However, I do understand what you're saying, and this is not just your exhibits. I mean, frankly, there have been many exhibits submitted by many parties. And as far as I can tell, many of those exhibits are not discussed at all in the written proposed testimony of the parties. So we're going to have to deal with that issue. Potentially, as necessary, I may give parties leave to file a supplemental written proposed testimony that describes the exhibits. But just so we're clear, I can't take an exhibit that's just a numbered document with no description by or no testimony describing it. I don't think, unless one of you can correct me if I'm wrong, I don't think I can just admit those into evidence and start considering them because I really have no context for the documents. But again, I don't want to get into this now. My ruling is we will wait and address this issue party by party, exhibit by exhibit when we get to that point. And I'll tell you, it may take a long time to go through some of the parties' exhibits. Particularly, I noticed the prosecution team filed 310 exhibits. And if there are objections to all of those or many of those, it's going to take a while to get through them, but we will. And that's the way I'm going to do that. It's just at the end of each party's case, we will, assuming the party still offers their exhibits into evidence, we will discuss objections. I was going to say this later, but since the issue has come up now, I'm going to say it now. And I'm going to talk slowly, so please, all of you, take notes. I'm sorry I didn't have time to write this out. This all just came up over the weekend, and I wrote this out for my script yesterday afternoon. But there are a few relevant legal authorities that apply here. And I'm telling you all now so you can look at those, because these, as far as I know, are the legal authorities I have to apply when deciding whether to admit exhibits. And of course, if there are other legal authorities I have missed at the appropriate time, any or all of you may raise those. So first of all, Government Code 11513, that's 11513, subdivision C is the general rule for evidence in this hearing, and it states, the hearing need not be conducted according to technical rules relating to evidence and witnesses, except as hereinafter provided. Any relevant evidence shall be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs, regardless of the existence of any common law or statutory rule which might make improper the admission of the evidence over objection in civil actions. And again, you can, if for those of you who aren't lawyers, you can Google Government Code 11513, and I think you can find this pretty quickly. Subdivision D of that same section states, hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but over timely objection shall not be sufficient in itself to support a finding unless it would be admissible over objection in civil actions. An objection is timely if made before submission of the case or on reconsideration. There are two regulations of the Water Board that apply here. California Code of Regulations, Title 23, Section 648.2 applies to official notice of documents. I sort of feel like I'm in law school here, but bear with me. Maybe you're all in law school, I don't know. That regulation states, the board or presiding officer may take official notice of such facts as may be judicially noticed by the courts of this state. Upon notice to the parties, official notice may also be taken of any generally accepted technical or scientific matter within the board's field of expertise, provided parties appearing at the hearing shall be informed of the matters to be noticed. The board or presiding officer shall specify the matters of which official notice is to be taken. Parties shall be given a reasonable opportunity on request to refute officially noticed technical or scientific matters in a matter to be determined by the board or presiding officer. And then the other regulation, California Code of Regulations, Title 23, Section 648.3, applies to evidence by reference. And it states, public records of the board that are relevant to the subject of the hearing and books, reports, and other evidence that have been prepared and published by a public agency, if otherwise admissible, may in the discretion of the board be received in evidence as exhibits by reference without the necessity of supplying copies to the board and other parties, provided the original or a copy is in the possession of the board and the specific file folder or other exact location where it can be found is identified. The party offering an exhibit by reference shall designate the particular portions on which the party relies. Each exhibit shall be appropriately identified and designated in the record as an exhibit of the party offering the exhibit or an exhibit of board staff. So when each party offers its exhibits into evidence, I will ask that party or its representative to state the purpose for which the party is offering each exhibit or group of exhibits. And then I will ask the other parties, or if any other party objects to the exhibit or group of exhibits. Objections may be based on, and I've written down 3 grounds, although there certainly may be others. A, whether there is any question about the authenticity of the exhibit. B, whether there is any question about the relevance of the exhibit. And C, whether the exhibit is hearsay, and if so, whether any exception to the hearsay rule applies. So if you're planning to offer any exhibits that may be hearsay or contain hearsay, then please be prepared to state any exceptions to the hearsay rule that you contend may apply. And these exceptions are stated in Evidence Code sections 1220 to 1370. And again, I'm just giving you advance notice to help you all prepare for this. And then finally, if any exhibit that has been offered by a party is not admissible under these statutes and regulations, I will consider whether I should accept it as a non-evidentiary policy statement under California Code of Regulations, Title 23, Section 648.5, Subdivision C. And for those of you who are participating in this hearing and are not attorneys, I apologize for the complexities of these rules, but these are the rules that I must follow in this proceeding. So with that, are there, and Mr. Lowe, I had noted you had raised your hand before. Do you still have a question or comment, or have I covered it?
No, you covered it. I just wanted to make sure that we had the right to defend them trying to get out of us testifying or presenting anything, which I wanted to make sure, and you clarified that.
Yes, when it's time for you to testify, you may testify. Of course, Mr. Donlin or any other party may object, and then I will rule on them at that time. But you absolutely have the right to offer your testimony, and we'll go from there at that time. So does anyone else have any questions on that? I mean, these questions of admissibility of exhibits obviously are very important, and that's why I'm spending the time now to describe what I think are the applicable rules, and then we will go through as necessary exhibit by exhibit to determine what's admissible into evidence, and thus may be considered by me in preparing my proposed order and by the board in deciding whether or not to adopt a final order. So any other questions on that? I know it's a lot to cover. Ms. Grady, go ahead.
Mr. Lilly, the other issue that was in the motion, which I think might help all of us, was a request for some clarification regarding the scope of the hearing. And I think that might help guide all of the participants in each of the roles in understanding and appreciating what is going to be considered relevant so that we can focus our efforts accordingly. Our understanding, as I noted in the document, is this hearing is being conducted pursuant to BlueTriton's request for a hearing regarding the report of investigation, the conclusion of the 6-year investigation conducted by the state board's prosecution team, which we appreciate. The comments were submitted by several public participants and the complaints that preceded those. But I guess I think there's some question and confusion regarding the scope of what's at issue. And if you could provide any guidance on that, it would be greatly appreciated.
All right, well, I can provide some now, but I think there's going to be more that we're going to have to address as the hearing goes forward. The notice of hearing, which I think was just November 17, specified the hearing issues. I can't remember if there was any revision to the hearing issues after that. I don't think there was, but just so we're clear that the notice specifies the hearing issues, and those are the issues. So I will be looking for evidence that is relevant to those hearing issues. And as far as exactly what that means, I think we're going to have to wait and address that. I'll say party by party and to some extent exhibit by exhibit as we go forward. But I think you've done a service to me and to the parties to raise some of your objections now. And that gives parties notice of what you will be stating when the time comes for objections, and then we will address them at that time. So I'm not prepared to say anything further about that now, but that is the clarification I can give for now. So does anybody else have any questions or comments? All right, Ms. Doty, go ahead. Your hand is up.
I have a question regarding compendiums of evidence that were presented as single exhibits. So for example, BlueTriton submitted letters written by its counsel to the water board that then would have, in some cases, 126, 96 pages of exhibits attached. So in terms of formulating objections, obviously we would object to the cover letter being entered into evidence for the truth of the matter it contains, since those are legal conclusions of BlueTriton. We don't necessarily object to the attachments. Many of them are the same as the ones that we are also proposing to enter into evidence. But I want to understand how we can handle that efficiently, because the compendiums are quite large and contain a variety of independent documents.
Well, I think that's about the way you'll have to state it when we get there. I don't know how better to handle that. I mean, I will take whatever time is necessary, and certainly I will look if there's a composite file of many documents that has been submitted as one exhibit. We'll look at the elements. We will go through that and take as much time as we need to do that. I don't know what more I can say about it now. I mean, the parties submitted the exhibits the way they did, but we will go through and I will consider arguments and then rule as appropriate. And it certainly is possible that parts of some composite exhibits will be admissible and other parts will not, or that certain parts will be admissible for certain purposes and other parts for other purposes. I mean, I know it'll be complicated, but I don't think I really have any choice of any other way to proceed. So I hope that answers, I don't know whether it totally answers your question, but basically I'm saying we will address that when the time comes. I did note the same thing when I was reading some of those composite exhibits, that it could be that different parts are going to be subject to different rulings on admissibility. But we will do that, don't worry.
Thank you.
My staff will have to spend a lot of time taking notes on exactly what's admitted and what's not admitted. But of course, we will have it all on the record as well. So, all right, Mr. Donlin, your hand is up now. Go ahead.
Thank you, Mr. Lilly. In addition to the APA statutes that you cited, Government Code Section 11513 C and D, I do want to note that Water Code Section 1110 C specifically says that these proceedings shall be conducted in accordance with Chapter 4.5 of the Government Code, which is also in the Administrative Procedures Act, commencing with Section 11400. I assume that those procedures will apply in this proceeding, and in particular, Article 6, the Administrative Adjudication Bill of Rights.
Absolutely, they will apply.
Okay.
The only reason I didn't mention them is I'm not sure. Just let me write this down. Yes, and if you think that there's anything that I am doing that is not consistent with those statutes, please let me know. The only reason I didn't mention them now is I didn't think any of those specifically applied to evidentiary rulings. But if you think some of them do, to particular offers of evidence, then please raise that point at the appropriate time.
Well, and maybe you're getting to this. I think you've only discussed topic one of the four topics that you wanted to discuss at this part of the hearing, and perhaps you will get to that. But to Mrs. Grady's point, or Ms. Grady's point earlier, I think defining the scope of the proceeding will be assisted by the other provisions of the Administrative Procedures Act.
Okay, well, I think we're just going to have to go through step by step on that. I can't do anything more about this issue in the abstract, but we certainly will address it as we need to during the hearing. All right, I'm just going to double check here. I don't think I see any other hands, so we will proceed. The second part of BlueTriton's motion in limine is to strike any evidence submitted by any member of the public to the prosecution team after January 20, 2018, which was the deadline the prosecution team set for comments on its 2017 report of investigation. That motion, the argument, I'm just going to read one paragraph of the motion, which I think summarizes the argument. Just a moment here, let me get that. On page 6, starting at line 11, the motion states, any public comments, including documents and information that were not submitted by February 9, 2018, by the February 9, 2018 public comment deadline, and I'm not sure why I had January 20, 2018. There may have been a difference there. I'm not sure it matters here. Should not have been considered by the State Water Board in its investigation and preparation of the 2021 report of investigation and draft cease and desist order, are not relevant to this hearing, and should be excluded on this basis. And I'm first going to tell you what my thoughts are on this, and then I'll ask the parties for comments. Water Code Section 1831, Subdivision C, states that the board may issue a cease and desist order under the statute, and then I quote, only after notice and an opportunity for hearing pursuant to Section 1834. Water Code Section 1834, Subdivision A, provides that the notice required by Section 1831 must, quote, contain a statement of facts and information that would tend to show the proscribed action and notification of the requirements of Subdivision B of that section, the Section 1834. Mr. Donlin, these statutes do not specify any particular process that the prosecution team must follow as it prepares this notice. And here in this case, the notice was effectively the draft cease and desist order and the backup documents that are referenced in that. And I am not aware of any statutory or other requirements that apply to the prosecution team's process. It appears that the only statutory requirement that applies here is that the prosecution team must provide the respondent with a notice that contains the required statement of facts and information. So, considering this statutory framework, is there any legal authority supporting your argument that the prosecution team should not have considered any comments, documents, or other information submitted after the prosecution team's deadline, which I'd put as January 20, 2018, but if we want to have it be February, we'll change that. Is there any legal argument that the prosecution team should not have considered any comments, documents, or other information submitted after the prosecution team's February 9, 2018 deadline?
Mr. Lilly, the issue is of, I guess, notice and fundamental fairness. The problem we're facing is that the state board posted, and still has posted on its website, that there was a close of public comment period and identified those comments received, made them available. And that was where BlueTriton was able to access that information that was being submitted to the state board in support of or in relation to the report of investigation. It appears, based on the filings that we've seen since, some included in the report of investigation itself, but many that have come into this process just in December, at the December 17th filing date, that there were substantially more documents that were not noticed, were not included or posted on the website, many of which that were not identified in the report of investigations. Unclear the relationship of those documents to the state board's analysis. Ultimately, the state board engaged in a 6-year investigation. The public has been invited to participate throughout, and BlueTriton due process requires that they have an opportunity to understand the basis of the findings against them and have opportunity to refute those. And the confusion lies, like I said, in large part around what the state board is noticing and making public and identifying on its website. The language quoted in the motion in limine is directly from the state board site that's still there, as far as I know today.
All right, but go ahead, excuse me.
No, I apologize. The link's in the footnote.
All right. So, Ms. Grady, though, I'm going to restate my question because I don't think you've really answered it. There's certainly, absolutely, the Administrative Hearings Office has a statutory and constitutional obligation to give BlueTriton due process of law. And we fully understand it's one of the fundamental principles of American jurisprudence, and we absolutely will follow that. By having our hearing notice, by having no ex parte communications, by having parties submit their exhibits, and by giving BlueTriton an opportunity to cross-examine those witnesses as necessary to submit rebuttal evidence. And one of the other things I'm going to talk about in a minute is how much time BlueTriton needs to do that. And I certainly have some sympathy and understanding to your argument that you got hit with a lot of exhibits in a very short time and that you may need more time to respond to those. But I guess my question I'm going to ask it one more time. I think the due process requirements apply to the AHO proceeding. I don't think, and please correct me if I'm wrong, but I don't think there's any statutory or other obligation for the prosecution team to provide BlueTriton with due process of law as it develops its draft CDO. I'm not sure the prosecution team had any obligation to talk to BlueTriton at all. I think they could just issue a draft CDO. Of course, BlueTriton then could request a hearing and due process requirements before the AHO would apply. But it seems that you're arguing that BlueTriton had some due process rights in the prosecution team's process that led to the draft CDO. And that's what I just don't understand.
Well, I think maybe that it wasn't communicated clearly enough. So there are two issues. One is due process with relationship to this hearing. And this goes back to the confusion I expressed in the papers, and I've expressed in this proceeding as well. Fundamentally, the understanding that we have is that this proceeding was to address the completeness or the basis of the state board prosecution team's findings in its report of investigation that led to the issuance of the draft CDO, which without our request for this hearing would have automatically gone into effect. What this has turned into instead seems to be an invitation to a number of folks who are acting essentially as private attorneys general, for which there is no statutory or regulatory authority in relation to these enforcement orders. This is different from certain legal constructs that do provide for those opportunities for individuals to step in, typically in actions in events where the state or the government does not do so after notice and opportunity. But here we have a situation where individual citizens submitted complaints to the state responded, the state conducted an investigation, the state invited all of these folks to participate, the state posted on its website and gave public notice that it had a deadline to submit additional documents. So I think the basis is in part fundamental fairness and the state applying its own requirements that it held out as being the standard and pulling that out, changing what those expectations were throughout the process and without making any public declaration that that was the case.
All right, so, and again, I just want to clarify, because I think maybe to some extent, we're talking past each other, and I want to try to avoid that. I agree with you, and this was in the hearing officer's ruling. Wait, where did you go? Oh, there you are. You jumped on my screen, excuse me. Move from there, excuse me. I agree that the prosecution team its statement of facts and information defines the general issues, and it has done that through its draft cease and desist order, and that other parties may not, as you say, in the format of a private attorney general, make new legal arguments. And that's why I rejected the request of some other parties for this hearing to consider public trust issues and waste and unreasonable use issues, because those would be beyond the scope of the draft cease and desist order. On the other hand, though, I think other parties have rights to offer evidence during this hearing, of course, following all the due process requirements, so BlueTriton can receive the evidence and respond to it. But I think other parties have rights to offer evidence supporting the legal arguments that the prosecution team has made in its draft cease and desist order, which is its statement of facts and information. So other parties are effectively constrained by the prosecution team's pleadings as far as what arguments they can make and what issues are relevant. But I don't think they're necessarily constrained by the specific evidence that the prosecution team assembled to prepare its draft cease and desist order. So I'll come back to you in a minute if you have any response to that. But first, Mr. Petrozelli, before I go to Ms. Fry and Ms. Lowe, I did want to ask you, you're representing the prosecution team, it's your draft cease and desist order. Do you have any comments on this issue?
Yes. we feel like the respondent is applying due process rules that really only apply in, the hearing part to the investigation. The division invited the public and the complainants to submit, additional information. It had to provide some kind of cutoff period because otherwise you keep getting more. But certainly there's nothing that precludes the division from conducting the investigation as it wishes. And it's certainly entitled in every reasonable sense to follow up on information that it received. And some of that may have included other information after the comment period. I will note that some of the exhibits that are objected to were received well before the comment period. Specifically, I believe PT 109 and PT 110 were actually water right complaints received at the genesis of the investigation. There's also a number of exhibits that are not objected to, notably correspondence between the prosecution team and the respondent, and other materials regarding the U.S. Forest Service special use permit. So they really seem to be picking and choosing and applying trying to apply a standard that just doesn't apply here.
All right. So let me go down my list. I'm not sure what order. I think Ms. Fry, your hand came up first. Would you like to comment on this?
Yes, as a member of the public, this is a public hearing, and there was an opportunity to submit evidence. And the water, as I read the California Constitution, the water belongs to the citizens of California. So the evidence provided was done. I know I was criticized in this motion, but it was submitted within the time frame as requested. And there's a difference between, can I just say this? I think there is a difference between due process of the hearing and considering an investigation. And trying to conflate the two seems illogical. Thank you.
All right, Ms. Doty, go ahead. Your hand is up. Ms. Fry, please take your hand down, your electronic hand. Ms. Doty, go ahead.
Thank you. So as far as the Bill of Rights go, what's afforded to BlueTriton is the right to call and examine witnesses, cross those witnesses, impeach witnesses, introduce exhibits, and rebut evidence, which my understanding from the schedule that's proposed, they will be allowed each of those opportunities. Additionally, some of the evidence that was submitted by BlueTriton was generated after 2018. So they themselves have held themselves to a different standard. And as you pointed out, the issues were defined. Most of the documents that have been submitted are public documents. In the case of the documents we submitted and that we intend to offer into evidence, Ms. Fry found them in public records, and often they are archives that contain records that were generated by predecessors of BlueTriton brands. So those records are as available or more available to them than they are to us. And we did address this in the written filing that we submitted this morning. I understand if you haven't had a chance to review that, but we were responding to a Friday afternoon filing.
That's fine, and I will read it. Thank you, Mr. Lowe, go ahead.
Yes, I worked for a government agency for 40 years that relied on public input to help make their decisions. So since the 2018 deadline, supposedly on commenting, we still, and I still, send information to the board, Division of Water Rights, if I have new information. So I never stopped sending things to them until this current process on this hearing, which confuses me still about public involvement, because I see BlueTriton trying to limit who can talk, what they can say, which is totally foreign to me. I've not seen this before in any kind of public involvement process that I've been involved in. So please be patient with me, but I have a right to send things to the board anytime I get new information, new science, and the board has to consider new science. There's not a deadline that new science has to be learned by, and we are getting new science related to this very process. So anyway, thank you. I think the board is doing the right thing. Thank you.
All right, thank you, Mr. Lowe. And please take your, oh, you did take your electronic hand down. Thank you. And just to clarify, we do have our deadlines for this hearing, which I think everyone has complied with, but you can't just keep submitting stuff to the board and expect us to consider it outside our hearing process. We do have the process that we are following for this hearing, but that I think is separate from the issue of whether or not documents could be submitted after January or February of 2018. All right, Ms. Doty, I want to try to wrap this up, but I see your hand is up. I'm going to go to you before I go back to Mr. Donlin.
I apologize. There was just one point that I forgot to make, which was that the outcome of this hearing will be potentially a new draft CDO, which you will be responsible to write. So if you were to honor the request of BlueTriton Brands, essentially the record would have closed a long time ago. I don't understand what the point of an evidentiary hearing would be at that point, other than to ratchet in one direction. At the exclusion of the public, as Mr. Lowe suggested, ratcheting the issues to be narrower and to exclude additional information. And as I understand it, the point of creating this office was to move water rights issues along more quickly and to provide better and defensible information to the water board. And excluding information would be contrary to that legislative intent.
All right, thank you. So Mr. Donlin, either you or Ms. Grady can give the final comments. I saw your hand was up. It's not up now. Do you want to say something?
I suspect, Mr. Lilly, that we will get to in due course the question that I was going to address. I do want to note, though, in response to the question that you posed to Ms. Grady earlier, that the government code, the APA, section 11425.10, which is in the Administrative Procedure Act.
You said that a little fast. Let me write it down. 11425 point what?
0.10.
Okay.
Subdivision A4 provides the adjudicative function.
Hang on. It works better if I have the statute in front of me, so just let me get it since I do just happen to have the government code here. Excuse me. I'm probably the only one who still uses paper, but it works for me. So bear with me. Okay, 11425.10. And you said A4.
A4.
Okay, go ahead.
The adjudicative function shall be separated from the investigative function, the prosecutorial and advocacy functions within the agency as provided in section 11425.3. And again, going to the question of due process in this proceeding, and I understand what you were saying to Ms. Grady. What our concern is that I think some of the parties believe that this proceeding is a continuation of the investigative process. And certainly new information that wasn't available to the board, whether it's in February of 2018 or April of 2021, is new information in this proceeding. And our concern is if we continue down this course, this proceeding will never end. We will continue to find new information that may or may not be relevant, and there will never be a disposition of this matter. So I think you will probably get to this in your analysis as the third or fourth item, but I just wanted to raise that point and to make, to cite that section of the APA.
All right. Well, thank you all for your comments. First of all, I don't quite understand, Mr. Donlin. I think the whole point of this hearing, having a separate office, is exactly to follow the statute you just said, to have a separate, an adjudicative function, an adjudicative office that's separate from the investigatory, prosecutorial, and advocacy functions. And that's exactly why we have a hearing team and a prosecution team. And for that same reason, I disagree with you when you say this hearing is a continuation of the investigatory process. I mean, the investigatory process was conducted by the prosecution team with no involvement from any member of the hearing team. And this hearing is going to be conducted by the hearing team, and the prosecution team will participate as an advocate, but as a party advocate without any ex parte communications with the hearing team. So I think it's not a continuation, it's a different process. And about the concern that this process never will end, believe me, I have directions from the 5 board members to get proposed orders to them promptly. And we will have a hearing. We certainly will have to go through different phases. Certainly we'll have rebuttal evidence, but we will get to an end and to a close of evidence, and then there will be a proposed order, which I will prepare with working with my colleagues in the AHO, and we'll transmit it to the board, and then the board will decide what to do with that. So it may take a while, but it will end. At least this round will end. Of course, the prosecution team in the future could bring us another action if they want to, if they think there are new facts that justify that, and that would be a new proceeding, but this proceeding will end. So anyway, on this part, I deny this part of BlueTriton's motion in limine for the reasons I just said. I am not aware of any statutory or other legal requirement that prohibits the prosecution team or any other party from presenting evidence during this hearing that is relevant to the hearing issues and that is otherwise admissible, regardless of whether or not such evidence was submitted to the prosecution team before a deadline that they set for their investigation process in either January or February of 2018. Of course, I expect parties to follow the deadlines and procedural requirements that we've specified for this hearing. So with that, let me go on to the third part of BlueTriton's motion in limine, and that's the part that asserts that various portions of the written proposed testimony of Steve Lowe, Amanda Fry, and Victor Vasquez contain opinions that these witnesses are not qualified to give. And I don't want to spend any time on this part of the motion now. I'm not going to rule on it one way or the other. When each party presents his, her, or its witnesses and offers it exhibits, BlueTriton and its attorneys and the attorneys for any other parties may object on the grounds that the witness's testimony contains improper opinions, and I will rule on those objections at that time. So we'll defer that ruling on that part of the motion until then. There'll be different times for each party's witnesses. Part number 4, although I don't think this was stated in BlueTriton's motion in limine, Mr. Donlin's January 7th letter, which preceded the motion in limine, raised the concern about the numerous documents that have been submitted as proposed exhibits by parties besides the prosecution team. And his letter states that BlueTriton is prepared to proceed with the testimony and evidence presented by the prosecution team and BlueTriton, but BlueTriton requests additional time to prepare for the part of the hearing that will consider other parties' testimony and exhibits. I'm hesitant to allow parties to comment on this because I think this is pretty darn clear. But let me just say my instinct is to allow BlueTriton additional time to prepare for cross-examination and so forth for the parties besides the prosecution team and BlueTriton. So let me say it a different way. My plan is to go forward today with the prosecution team putting on its exhibits, its testimony and exhibits. Then we'll rule on admissibility of those exhibits, assuming there are objections. And then we'll proceed probably tomorrow with BlueTriton putting on its evidence and exhibits, testimony and exhibits. And parties, of course, can cross-examine that, and we'll go through that process and then consider admissibility of those exhibits. And then I will, seeing on where we are, but assuming we finish sometime tomorrow with that, which I hope we will. And again, I'm just hoping keeping the matter going forward. I know this testimony is all very important. Then I'm prepared to consider giving everyone a break for a day to basically allow everyone to regroup and go through the exhibits, including me, so we're fully prepared to consider those, and particularly the numerous exhibits submitted by Story of Stuff Project and Amanda Fry. So that, at least tentatively, our schedule would be then to take that up on Thursday. So Mr. Donlin, maybe that helps, but do you have any further comments on this issue or on my proposal?
Not at this time, Mr. Lilly. If I could maybe reserve the right to confer with my colleagues about this. I would ask that you continue and that we can double back on this question later in this proceeding this morning so that I can check with them. I don't want to commit others' time that is not appropriate for me to commit. And as you can see behind me, the red binders are the documents that were submitted on December 17th by Story of Stuff and Amanda Fry. The blue binders are the prosecution's case. We received more from those other parties. And it's a massive record that will take some time. So I will say to you now, yes, we will do our best to work through those documents so that we're prepared for cross-examination and testimony on Thursday, I think is what you were saying. But if you would allow me an opportunity to confer with my colleagues, I would appreciate it.
All right. So that's reasonable. I understand. So let's plan to, if you can make a note and remind me if I forget, because I may. But as we get near the end of the hearing day today, let's talk about it then, because we'll know better where we are on the schedule for going forward. I mean, just so we're clear, I want to make sure everybody has an opportunity to present his, her, or its testimony and exhibits. But I also do want to give everyone an opportunity to fairly prepare for that. And, I certainly, I mean, you said you had a couple of people out with COVID, which is unfortunate, but it's what's going around these days. And I certainly understand it's a lot of material to go through and that you want to be fully prepared for that. So Mr. Petrozelli, your hand is up. Please go ahead.
Mr. Lilly, I don't think it's unreasonable, especially when we talk about order of presentation, to state that certain parties may not present are expected to present their case in chief no earlier than a certain day or a certain part of the day. I would hesitate to say now that we'll take a break on Wednesday, just because we don't know how long it'll take to get through cross-examination of the prosecution team and then cross-examination of BlueTriton's witness. So I would not want to delay this part of the hearing process after this week. And I believe we want to be sure we give all of the parties who are presenting cases in chief an equal and fair opportunity to present those cases.
Okay, so Mr. Petrozelli, first of all, based on what you said, what I said may not have been clear, and I apologize for that. My plan is, and maybe I'll say it another way, my plan is to go forward with the prosecution team's case in chief starting today, this morning after a break. And then after the prosecution's case in chief is done, to go forward with BlueTriton's case in chief and finish all that. And then we will see where we are. The only reason I said Wednesday is I sort of think it might be that we will be wrapping up with BlueTriton sometime on Tuesday, but that's to be determined. And at that point, we will see how much additional time people think is appropriate, or whether how long of a break is appropriate, and how to go forward. I certainly would like to finish this hearing this week, but I am not going to rush it through if doing so would not be fair to any parties for preparation. And Mr. Donlan's underneath the plants in his background has demonstrated fairly vividly how many exhibits he has to deal with. And, and in fairness to BlueTriton, it is sort of everyone against them as far as preparing for this. I mean, they do have numerous qualified attorneys on their team, but still it's a lot of material to go through. So anyway, that's the clarification. We'll see where we are. I really don't want to belabor this now because we're going to spend more time now talking about where we might be by tomorrow afternoon, and we'll know better tomorrow afternoon. But I'll go really quickly to you, Mr. Donlan. Your hand is up. Go ahead.
And I apologize, Mr. Lilly, for going backwards. You finished with your item 2 and then rushed through 3 and 4 pretty quickly. I would like clarification on how you ruled on the issue of the documents that were received after the comment period deadline in 2018, and also if that ruling also applies to documents that came into this record after the draft cease and desist order was issued in April of 2021.
All
and
right.
you weren't clear about where that line is.
All right. I don't believe your motion separately addressed documents that, I don't know, we say came into this record after the cease and desist order was issued in April of last year. But anyway, my ruling is that part of the motion in limine is denied. Whether or not specific documents were submitted to the prosecution team at any date or were submitted to BlueTriton at any date is not grounds for objection in and of itself. Of course, you still may object to any of those documents on any of the other grounds that apply to evidentiary rules, but that specific chronology is not going to be a basis for an objection that I am going to sustain. Is that clear?
I believe so. I think we will probably have more conversation about this as we work through the testimony.
All right. Well, and that certainly is appropriate. You may raise objections to parties' exhibits when we get to them. Okay. So I think we can, I don't see any other hands up. Let me just double check here on screen 2. I think we're okay. So I'm going to go forward. So before we get started with cases in chief, is there anybody who is not a party or representing a party to this case who wants to give an oral policy statement? And again, just so we're clear, we've received numerous written policy statements, which we will consider. They are part of the record, and we and the board will consider them. They're not evidence, but we can consider them as arguments set forth by interested members of the public. But does anybody want to offer an oral policy statement now? And Ms. Dickinson, I see your hand is up, and I'll let you just go ahead and do that. Please, 5 minutes maximum for oral statements or oral summary of your written statement.
Thank you, Mr. Lilly. My name is Mary Ann Dickinson. I'm a resident of Lake Arrowhead in San Bernardino County. By way of introduction, I'm the past chair of the board of the Lake Arrowhead Community Services District and a current member of the San Bernardino Valley Municipal Water District Headwaters Resiliency Partnership Committee. I am the recently retired CEO of the national nonprofit organization, the Alliance for Water Efficiency, and I'm currently a water resources consultant. I have worked in the water resources field for over 45 years. I'm appearing today to strongly support the July 8th, 2021 draft cease and desist order issued by the State Water Resources Control Board, which is the subject of this hearing, and to urge the board to finalize this order and to permanently reduce the withdrawal of water in Strawberry Creek to the identified lawful water right of 7.26 acre feet per year. As stated in the draft cease and desist order, Nestle's reported extractions from the Strawberry Creek watershed in the National Forest from 1947 through to 2015 have averaged instead 192 acre feet per year, which is equivalent to 62.6 million gallons per year. That's 26 times the legal water right as determined by the State Water Resources Control Board Enforcement Unit, Division of Water Rights. Those of us who care about the health of the San Bernardino National Forest have been waiting 6 years for this cease and desist order. As the community has sadly observed the dewatering of Strawberry Creek with these extractions, multiple requests were made to the state board for a water rights verification, as the record shows. These requests went as far back as March 2015, asking for a halt to water diversions until the water rights could be verified and the environmental impacts could be properly assessed. Local environmental groups who are here with us today, including the Save Our Forest Association, were also concerned about Nestle's expired U.S. Forest Service permit, and they requested meetings as early as September 2014 on this issue. A once healthy stream that historical records are showing had sufficient regular flow to support fish, Strawberry Creek now has been literally destroyed by over-extraction. As a water professional that has been working in the state of California for quite some time, I do see firsthand the devastating effects that California's droughts, especially the current mega drought we are in now, have had on water resources availability in general. Extreme drought conditions that once were rare have been occurring with increased frequency throughout the state, with devastating effects to reservoir levels, to water supply availability, to fisheries, and flows in riparian habitats. Strawberry Creek's no exception to this. A high desert environment such as the San Bernardino National Forest is already naturally arid. The drought has made it even drier, having a further deleterious effect on the availability of water in Strawberry Creek and on the indigenous plants and animals that depend on it in the National Forest. This extreme drought that the state's currently experiencing already is a serious impact to the creek. Diversions at the level that Nestle was taking, and now BlueTriton, should have been curtailed as other water withdrawals around the state have been over the past several years of extreme drought. Lastly, the diminution of Strawberry Creek flows, we think also has affected the headwaters drainage potential to the downstream water rights of the San Bernardino Valley Municipal Water District. This is also of great concern as it potentially is affecting a water supplier's water resource availability to provide safe drinking water to its customers. So in conclusion, I strongly support the issuance of the draft cease and desist order as a public citizen, and I wish to commend the State Water Resources Control Board for its careful analysis and conscientious work over the years on this very important issue. This order needs to be finalized and consistently enforced, and most importantly, communicated directly to the U.S. Forest Service as well. Thank you, Mr. Lilly, for the opportunity to comment.
All right, thank you, Ms. Dickinson. So Ms. Starbuck, I see your hand is up. Would you like to give an oral policy statement or an oral summary of your written statement? And you have to go off mute so we can hear you.
Yes,
we're all still learning with Zoom. Yeah. Please go ahead.
Thank you, Mr. Lilly. Yes, I'm Betsy Starbuck. I'm president of the League of Women Voters of the San Bernardino area. I appreciate the opportunity to present a public comment today that follows the League's submission of a non-evidentiary statement to the AHO on August 3rd, 2021, and a comment letter to the Division of Water Rights on February 9th, 2018. Today, the League is appearing to strongly support the July 8, 2021 draft cease and desist order issued by the State Water Resources Control Board and reduce the withdrawal of water in Strawberry Creek to the lawful water right of 7.26 acre feet per year. The total production from the facilities that have operated in the San Bernardino National Forest in the Strawberry Creek watershed since 1947 have served just one interest: to enable the bottling and sale of the Arrowhead Mountain spring water by BlueTriton and its predecessor, Nestle Waters of North America, to consumers in the United States and internationally. Records provided to the public from the San Bernardino Valley Municipal Water District document that more than 13,000 acre-feet has been extracted from Strawberry Creek Watershed for this purpose, resulting in not only the destruction of riparian and aquatic habitat, but also affecting the headwaters drainage from Strawberry Creek to downstream water users in the San Bernardino Valley. Members of the League of Women Voters of the San Bernardino area who reside in both the San Bernardino Valley and the San Bernardino National Forest further urge the state to act expeditiously to reduce the withdrawal of water in Strawberry Creek to the lawful water right of 7.26 acre-feet per year, considering how seriously this region has been gripped by drought for most of the last 22 years. In this environment that is already naturally dry, the Strawberry Creek watershed is subject to wildfire risks that are worsening from climate change. Excuse me. And major fires that begin in the San Bernardino National Forest have been fueled by wind, driving wildfires down the south-facing slopes above the city of San Bernardino, and have destroyed more than 1,000 homes in the last 50 years. In conclusion, the League of Women Voters of the San Bernardino area strongly urges the issuance of the draft cease and desist order and appreciates the careful analysis and conscientious work by the state on this important issue.
All right, thank you, Ms. Starbuck. And I don't see other hands for policy statements, so we'll go to you, Mr. Petrozelli. You have your hand. I assume you're not going to make a policy statement, but please go ahead.
No, I just had a housekeeping matter that I wanted to make sure I could raise. I need to ask for a hard stop today, Wednesday, and Friday in order to pick up my son from childcare. That's as late as I can leave to get there without incurring late pickup fees.
What time is your hard stop that you request?
5 p.m.
Okay. Yes, I certainly think that is appropriate. And we probably will finish before then, but remind me if we're getting to 5 and I haven't stopped, because I certainly respect not asking you or anyone else to go later. In the COVID era, we all have to juggle responsibilities as well as we can.
And before jumping into our case in chief, I'd like to request a brief break, at least.
We will, don't worry.
Okay.
I and the court reporter want that too. But let me just tell you what I'm going to do with our process, and then we will take our break. So our hearing notice on pages 19 to 21, and as I discussed during the pre-hearing conference, allows each party to present its case in chief, and that may involve an opening statement if desired for a maximum of 5 minutes. And then after I administer the oath to each witness, the witness may give a summary, and I can't emphasize summary, of his or her written testimony, not a recitation of the whole testimony. I've read them. I will read each witness's entire written testimony before that witness testifies, but this is just a summary. I will allow 45 minutes maximum for each party to present the summaries of all of that party's witnesses. After that, I will allow all the other parties to ask cross-examination questions of the party's witnesses. Each party's cross-examination initially will be limited to 45 minutes, but I may allow additional time if the cross-examining party demonstrates through an offer of proof that there is good cause for me to allow additional time. And then if appropriate, I will allow redirect and recross questions, which will be limited to the matters the witnesses already have testified to. And finally, I may ask witnesses questions at any time. After all of the parties have presented their cases in chief, we will discuss whether any party wants to present rebuttal evidence, and the hearing notice specifies the dates and the process for submittal of written proposed testimony for rebuttal and the dates for that hearing. The hearing notice refers to closing statements and legal arguments. My plan is to have the parties file written closing briefs rather than oral closing statements, and we will set the schedule for that at the end of the hearing. My plan is for the parties to present their cases in chief in this order. The prosecution team will go first, BlueTriton will go second, and then that will be followed by Steve Lowe, Anthony Serrano, Save Our Forest Association, and that's Hugh Bilecki, Story of Stuff Project, and Amanda Fry. And as I said, we will discuss potentially taking an extended break between BlueTriton's case in chief and Steve Lowe's case in chief. Does anybody have any questions about these hearing procedures before we begin? Okay, hearing none.
Mr. Lilly, I apologize, that was my hand was up.
Oh, I'm sorry. Excuse me,
That's
Ms. Grady,
okay.
go ahead.
No problem. I had a couple just procedural questions. With respect to the witnesses, just to confirm, we're going to go witness one, cross if appropriate, or approved by you, redirect, recross, and then next witness. Is that correct?
No, thank you for that question for clarification. My plan, at least with the prosecution team, which has 2 witnesses, will be for them to have the summaries, present their summaries of both witnesses first, and then we'll proceed with cross-examination of them as a panel. We found that that's more efficient to do it that way, because frequently what happens is one witness says, well, my colleague is really in a better position than I am to answer that question. And also it just ends up going more quickly. So we'll do that as a panel approach. So any other questions about that?
Yes, Mr. Lilly, I'm sorry.
Okay, go ahead, Mr. Donlan. I meant for Ms. Brady, but her hand's not up. So go ahead, Mr. Donlan.
Yes, I think the testimony of Mr. Vasquez and Mr. Eggers is quite different. They testified to different issues in this hearing, and there are many issues. We would request that we proceed through a single witness and that they be cross-examined individually. I think cross-examination will be lengthy. Ours will certainly, of both Mr. Eggers and Mr. Vasquez, will be longer than 45 minutes for each of them. And I think you will find it ultimately more efficient to have them testify and have the examination completed for each witness individually.
All right, Mr. Petroselli, these are your witnesses and your hand is up. Do you have any comments on this?
Okay. Yes. I mean, first of all, I wanted to clarify that we actually have 3 witnesses. Even though only 2 witnesses have submitted written testimony, we have Natalie Stork available for cross-examination. She authored and was the staff lead for the initial report of investigation issued in 2017. When we have a change in staff during an investigation or a process, that's not uncommon. So I wanted to clarify that. As for individual versus panel cross-examination, the witnesses are testifying as a panel. The hearing procedures specifically say 45 minutes per panel. If witnesses are testifying as a panel, BlueTriton can use its time as they choose. They want to use 25 minutes for Mr. Vasquez and 20 minutes for Mr. Eggers. That's up to them. And at the end of that, if they want additional time over the 45 minutes, they can, as you stated, make an offer of proof.
All right. Anybody else have any comments on this? So, Mr. Donlin,
I had another question. I'm sorry, Mr. Lilly.
I'm sorry.
Raising my old-fashioned hand. I'm not quick on finding that button.
No, that's fine. It's just that your tile is exact opposite corner of the screen from Mr. Donlin's where it is now. So I apologize. Please go ahead.
Apologies. Yeah, I'm one of the people quarantined, so I don't get to be by anybody. With respect,
we're all quarantined for this hearing, so go ahead.
Yeah. With respect to the comment that Mr. Petrozelli made, I'll be candid, I'm quite confused. They submitted summaries of evidence for 2 separate witnesses and didn't have any indication that it was a panel. So that is, I'm a little confused as to how we were supposed to anticipate that way.
So Mr. Petrozelli, I didn't dig it out, but did your notice of intent list Ms. Stork as another witness?
It did.
All right. So Ms. Grady, the water board proceedings are not exactly like a court proceeding, and in some ways they're a little more informal. And we do normally allow panels where if a cross-examination question goes beyond the scope of a witness's direct testimony, which is allowed under Government Code 11513 subdivision B, as long as it still is within the hearing issues, we do allow other witnesses to respond if appropriate, particularly if there's a question specifically about the 2017 ROI that Ms. Stork is most qualified to answer. I mean, frankly, our goal here is to have the most qualified witness answer each question. So that is why we do allow that. Again, it's got to be within the scope of the hearing issues. So another question, go ahead.
Yeah, I apologize. My confusion was not about Mr. Petrozelli was making comments about his direct. The way he stated it, and Mr. Petrozelli, please certainly correct me if I'm wrong, he stated they were presenting their witnesses as a panel, which I understood him to mean on direct. And then the way he articulated the time that we would have to cross-examine as being limited to, he divided up the 45 minutes between the two, stating that we would have less than 45 minutes, that we would have a combined total 45 minutes to do any cross-examination. And that's my confusion.
So first of all, Ms. Stork will not be giving any direct testimony because she did not submit any written proposed testimony, but she will be available to answer questions on cross-examination as appropriate. Secondly, the hearing notice specifically says cross-examination initially is limited to 45 minutes per panel of witnesses. So the way Mr. Petrozelli described that is correct. However, as I said earlier, and I will repeat now, upon an offer of proof, which will mainly be, in this case, presumably additional topics that the questioner believes need to be covered on cross-examination, I will consider allowing more than 45 minutes for cross-examination of a panel. And I don't think this is going to happen in every case, but I mean, I'll just say up front, just so there's no suspense here, I certainly understand that BlueTriton may need more than 45 minutes to cross-examination the panel of prosecution team witnesses because there's so much material in there. And of course, it's very important that they have that right to do that. So that's my clarification. So Mr. Sanders, we haven't heard from you yet this morning. Please go ahead. Your hand is up.
Morning, Mr. Lilly. My comment is that the hearing notice of November 17th specifically does not designate that it's absolute that it has to be a panel. It specifically says if a party presents multiple witnesses, the hearing officer will decide whether the party's witnesses will be cross-examined individually or as a panel or panels. And then cross-examinations will initially be limited to 45 minutes per witness or panel of witnesses. Ms. Grady, specifically noted that the testimony of each of the individual witnesses that have testimony on behalf of the prosecution team are very unique. There is no overlap of exhibits coming in. Mr. Eggers is primarily addressing the issue of the pre-14 rights. Mr. Vasquez is addressing the hydrology of the area and the groundwater issues. They are very distinct. It will be, in my opinion, an inefficient use of time if we go back and forth on those issues between the panelists in addressing a question, because they were very clear as to exactly what it was they were testifying to.
All right, Mr. Petrozelli, your hand is up. Go ahead.
Mr. Lilly, having helped the witnesses prepare their written testimony, there is some overlap between their testimonies.
Okay, we don't need to belabor this. Mr. Sanders is right. This is discretionary with the hearing officer. The notice says that. I think it's inherently in the hearing officer's discretion. Again, I don't know exactly how I have very little idea how cross-examination is going to play out here. Our normal practice is to have witnesses testify as a panel. My instinct is that's going to be more efficient. They may have different subject matters that may or may not overlap, but the bottom line is they both concern the issues raised, the hearing issues and the issues raised by the draft cease and desist order. So I'm going to proceed with a panel. So Mr. Petrozelli first will provide questions for summaries. And again, I repeat, summaries. And I notice the prosecution team has submitted slides, so that should help summarize the testimony of both Mr. Vasquez and Mr. Eggers. And then we will have cross-examination of the panel of Mr. Vasquez, Mr. Eggers, and Ms. Stork, and we will go through party by party on that. So that's, again, it's a judgment call on my part. I think either way, parties will have their rights to conduct cross-examination. I just think that's going to be more efficient in case there is overlap. So that's what we're going to do. So, okay. I need a break. I think the court reporter needs a break, and probably all of you wouldn't mind a break either. So I have 10:48 on my clock. So let's break until 11:05, and then we will proceed at least, and hopefully we can complete the summaries of the prosecution team's witnesses and then take a lunch break. So at this point, please, you can turn off your camera and your microphone, but don't log off, because you may have trouble logging back on, and I will see everybody at 11:05. Thank you.
The court reporter is back, Mr. Lilly. And you are muted for your info.
You think I'd learn? I've only been doing Zooms for about 2 years. Thank you, Ms. Stiles.
You're welcome.
Okay, I'll just give a moment for everybody to get back here. We did have, I see Mr. Serrano was able to join by telephone. So, Mr. Serrano, I don't know if you want to, if you can go off mute and just confirm that you can hear us, which everyone else has entered their appearance today. If not, that's fine. Okay. Well, we're going to go forward then. I have received Prosecution Team Exhibits PT1 through PT310, and it appears that the prosecution team plans to call 2 witnesses, Victor Vasquez and Thomas Eggers, and then also Mr. Petrozelli confirmed that Natalie Stork will be available potentially to answer cross-examination questions. So with that, Mr. Vasquez, I'm going to find you. There you are. Please go off mute, raise your right hand. There we go, so we can see it. Do you swear that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And I'll just go ahead with the other 2 witnesses. Mr. Eggers, please raise your right hand. Do you swear that the testimony you will be giving in this hearing, oops, you just went, there we go. Try again. You went on and off video there. Mr. Eggers, do you swear that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, Ms. Eggers. And Ms. Stork, please raise your right hand. Do you swear that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
All right, thank you. And with that, Mr. Petrozelli, you may proceed with your questions for Mr. Vasquez. And just wait one moment. I'm going to get the slides here. I told you I still do things with paper. I know most of you go electronically. And incidentally, I do apologize. The State Water Resource Control Board's entire computer system was down on Saturday for maintenance. So I saw some of you had trouble accessing things then, but that problem should be taken care of and we should now be ready to go. So with that, Mr. Petrozelli, you may proceed.
So I do have an opening statement.
Oh, I'm sorry. I did say you could have an opening statement. So you have 5 minutes for opening statement. Please
And
go
if
ahead.
it helps, Mr. Vasquez's presentation is PT9 and Mr. Eggers is PT12.
All right. So while you're doing your open, I mean, my staff is really, really good, but they can be getting PT9 ready to put up while you're giving your opening statement.
Thank
Don't
you.
put it up until Mr. Vasquez starts testifying. So with that, Mr. Petrozelli, I have 11:10. You have 5 minutes. Please proceed.
Okay, good morning, Mr. Lilly, hearing team. To start, I would like to thank Amanda Fry, Steve Lowe, and other members of the public, the hundreds who submitted complaints and information that helped us develop this case. Without them, we wouldn't be here. And we are here because the board should issue a cease and desist order against the respondent, BlueTriton Brands, for its diversions from springs in the San Bernardino National Forest, springs that are the headwaters of Strawberry Creek, a tributary to East Twin Creek and the fully appropriated Santa Ana River. The respondent ships this water to various factories for bottling, one in downtown Los Angeles. The respondent constructed horizontal tunnels and drilled boreholes at or adjacent to those natural springs. These tunnels and boreholes were engineered to intercept water that would have naturally discharged from the springs. The law is clear that these diversions are subject to the board's water right permitting authority. As the board has recently explained, its permitting authority applies to diversions from streams, and the law presumes that a spring tributary to a stream is part of that stream, subject to riparian use and appropriation. The board's permitting authority is not limited by the fact that the flow of a stream or spring may be supported by hydrologically interconnected groundwater. even if a diversion from a spring increases the amount of hydrologically interconnected groundwater flowing into the surface stream or spring, that diversion is still subject to the board's permitting authority and the prohibition against unauthorized diversion or use of water under Section 1052 of the Water Code. If a diverter could dodge the board's permitting authority just by putting a pipe in the ground at a spring, it would be open season on headwater springs. We know the respondent diverts from springs tributary to streams. We know because our staff saw it in the field and they saw it on maps. Their observations are consistent with technical reports the respondent's consultant prepared for its FDA licensing and further corroborated by statements the respondent made during the investigation. In the words of Justice Mosk, if an object looks like a duck, walks like a duck, and quacks like a duck, it is likely to be a duck. In the same way, we can conclude from overwhelming evidence that the respondent diverts from springs tributary to streams. The board's permitting authority applies, as does the prohibition against unauthorized diversion or use of water in excess of a right. And the respondent is exceeding its right. According to the respondent, its corporate predecessor, the California Consolidated Water Company, CCWC, purchased rights from the Arrowhead Springs Corporation, ASC, the owner of the Arrowhead Springs Hotel, through a series of contracts from 1929 to 1931. The respondent further claimed those rights were confirmed by the judgment in Del Rosa Mutual Water Company v. DJ Carpenter et al., the Del Rosa judgment. But the judgment is ambiguous as to what rights, if any, CCWC had. It also stated that it did not affect, amend, or otherwise impair any contracts then existing between CCWC and ASC. Those contracts are at best ambiguous as to what water rights were finally transferred, and that is after CCWC accused ASC of fraud. Staff therefore reviewed historical information. They found evidence supporting a right of up to 7.26 acre-feet a year. You can only sell what you have, so the most that could have been transferred through the contracts and confirmed in the Del Rosa judgment was 7.26 acre-feet a year. That is with very generous and conservative assumptions. Even then, the respondent has exceeded this amount almost every year since 1947. Now, Victor Vasquez and Tomas Eggers, both from the Division of Water Rights, will present their direct testimony. Natalie Stork, who authored the 2017 report of investigation, is available to answer questions about that part of the investigation. Mr. Vasquez, take it away.
Good morning. My name is Victor Vasquez. I am a senior.
Sorry, excuse me, Mr. Vasquez.
Yes.
I went on mute and then started talking. You'd think I'd learn after 2 years of Zoom calls, but thank you, Mr. Petrozelli. Does that conclude your opening statement?
Yes, it does.
All right. And Mr. Vasquez, you may proceed to summarize your written testimony. Please go ahead.
I have a question. Will the slides be up?
We will put the slides up. Thank you. So if I will ask my staff, please put up PT 9 on the screen. And then I told you they're good. So Mr. Vasquez, just as you go forward, just say next slide, please, every time you want to move to a new slide. And we now have slide 1 of PT 9 on the screen.
Okay, thank you. Good morning. My name is Victor Vasquez. I am a senior water resource control engineer in the enforcement section of the Division of Water Rights. Written testimony is offered into evidence as Exhibit PT7, and my statement of qualifications is Exhibit PT8. I have taken the oath. This presentation will cover the following: the complaint investigation, the basis for why and when spring diversions are subject to the permitting authority of the State Water Board, the respondent's points of diversion and diversion works, and recommendations for a cease and desist order. Next slide, please. The respondent operates spring water diversion facilities at the headwaters of the Strawberry Creek Watershed in the San Bernardino National Forest in San Bernardino County, California. The area outlined in magenta in this map shows the Strawberry Creek watershed, which is within the San Bernardino Mountains. The respondent diverts water from 8 springs and uses 13 points of diversion, or PODs, consisting of 3 tunnels and 10 horizontal boreholes. The respondent uses the diverted spring water for bottling at various locations, including a bottling plant in downtown Los Angeles. The respondent's operations occur about 9 miles upstream of the Santa Ana River, a fully appropriated adjudicated watershed. Downtown San Bernardino is located 7 miles southwest of the respondent's operations. Next slide.
Excuse me, Mr. Vasquez.
Yes.
Before you go to the next slide, just for orientation, this is a useful background map. The creek that runs north to south to the left of the Strawberry Creek watershed, do you see it? It starts just below the 189 highway symbol. Is that in fact Coldwater Canyon?
I believe the watershed in magenta, or part of the Coldwater Canyon, is within the borders of in the outline of the magenta outline.
Okay, you may proceed. We will want, I'd like to have, because I know some of the documents refer to Coldwater Canyon, so I would like to get that clarified, but please go ahead.
Thank you. Next slide, please. We received 9 complaints against the respondent between April 2015 and September 2017, including a petition signed by 500 people. While the complaints had several allegations, the main allegation was that the respondent diverted water from the springs in the Strawberry Creek watershed without a valid basis of water right. We initiated a complaint investigation in July 2015, and I assigned then engineering geologist Natalie Stork as lead staff. We conducted a field inspection in June 2016, which involved flying by helicopter and hiking through the Strawberry Creek watershed, accompanied by the respondent's representatives. We issued a report of investigation, or ROI, in December 2017. Parties could submit written comments with supporting evidence by February 9th, 2018, if they disagreed with the ROI, and we did receive significant new information. After Ms. Stork left the Division of Water Rights, I assigned Water Resource Control Engineer Tomas Eggers as lead staff to continue the investigation. The new information received led to revised analyses in some ROI sections, and we issued a revised ROI in April 2021 with a draft cease and desist order. Next slide, please. The respondent claims it has valid rights to all water it diverts from the springs in the Strawberry Creek watershed. However, the available evidence from our investigation indicates most of the respondent's diversions require a water right permit from the State Water Board and are therefore unauthorized. The main conclusions in the 2021 ROI are: the respondent may claim an appropriation of up to 7.26 acre-feet annually under a pre-1914 basis of right with a 1909 priority date. The respondent likely has an appropriative groundwater claim to an unknown amount of percolating groundwater that would not have flowed in a natural surface channel elsewhere in the watershed. And the respondent's diversion and use of water within the permitting authority of the State Water Board that is greater than 7.26 acre-feet during a year is an unauthorized diversion. Next slide. Ms. Stork and I determined if the respondent's spring water sources were subject to the State Water Board's permitting authority based on legal guidance from the Office of Enforcement. Previous State Water Board and court decisions concluded that a spring that is tributary to a stream is part of that stream, and diverting water from that spring would require a water right permit from the State Water Board. The party diverting from a spring that is part of a stream has the burden to prove that a water right permit is not required. The natural flow from the respondent's spring diversions was within the board's permitting authority if the diversion was at a natural spring orifice or diverted water away from a natural spring orifice, and natural flows from the spring orifice would have flowed into or contributed to flow in a natural channel. The natural channel could be a natural swale, a tributary ravine, or a topographic drainage. Spring sources are often artificially modified by digging them out or by installing spring boxes, tunnels, or boreholes. Board decisions have issued permits for spring diversions using every one of these methods. The natural flow of a spring is the flow that would have discharged from the spring prior to any human modification or disturbance. The flow from a modified spring may have both natural flow and additional flow, broadly referred to as developed flow. The increase in flow may still be subject to the board's permitting authority, such as when the modification of a spring increases flow at the modified spring, but decreases flow downstream or dewaters upgradient or downgradient springs. Modifications may also cause the natural flow of the modified spring to peak sooner and also taper sooner during a water year. The increase in flow from a modified spring is not subject to the board's permitting authority if the increase over natural flow augments the available water in the watershed and would not have otherwise contributed flow to a natural channel. If the water from the spring source was within the board's permitting authority and the respondent did not have an alternate basis of right for the water diverted from the spring, then the diversion would be unauthorized. Next slide. This figure is from Exhibit PT23, the 1999 Dames and Moore report, which the respondent commissioned for its FDA licensing. This figure is a topographic map of the Strawberry Creek watershed where the respondent's spring diversions are located. The town of Rim Forest is located about 1,000 feet up gradient from the closest spring diversion at the top. You can see natural channels or topographic drainages on this map as a series of inverted V's or U's along the contour lines extending down gradient from the markers, indicating the location of the springs. The PODs subject to the board's permitting authority divert from springs 1, 2, 3, 7, and 8. These springs are adjacent to natural channels tributary to Strawberry Creek or very near. These are natural springs and would have contributed flow to these nearby channels had the respondent not diverted their flows. The respondent originally developed these springs by either constructing a tunnel into the mountain horizontally at the spring orifice or drilling horizontal boreholes into the orifice. These methods of spring development obliterated the original spring orifices and captured natural spring flows, which then drained by gravity into conveyance pipelines shown as red lines on this map, which run down the mountain to the Waterman Canyon water storage tank and truck loading facilities. Next slide. The geology of the Strawberry Creek watershed explains how springs may form in the watershed and how the respondents' PODs may have been sited where they are. According to the 2021 ROI, bedrock in the Strawberry Creek watershed is highly weathered, intrusive, crystalline igneous rocks, and the area is traversed by several east-west oriented fault splays associated with the Devil Canyon Fault. Groundwater recharge occurs from infiltration of precipitation into the fractured and faulted bedrock. Vertical clayey layers called fault gouges at fault planes may act as barriers to groundwater flow, which is supported by information contained in well construction logs included in the Dames and Moore report. General technical references on spring development indicate that selection of sites for spring development is based on observing existing springs, seeps, and water-loving plants, or from known geology. The diagram on this slide is from a technical reference about constructing horizontal wells or boreholes. It shows a dike spring formation with an impervious barrier with accumulated water in the aquifer on the right side of the barrier. This is a good representation of the springs along fault gouges in the Strawberry Creek watershed. A spring or seep would likely occur at the red arrow where the water table and impervious barrier reach the ground surface. According to the technical reference, the objective in horizontal well development of a dike formation is to drill through the barrier somewhere below the seep and tap the storage water. Next slide. The respondent designed and engineered its diversion works to intercept water that would have naturally discharged from the springs. According to the Dames and Moore report, springs were developed with engineered collection facilities and boreholes installed at the natural spring orifice. In later years, several of the original tunnels or boreholes were replaced by drilling new boreholes in the vicinity of the original tunnel or borehole to intercept the water that would normally flow through the natural spring orifice. These new boreholes were referred to as offset boreholes. Consequently, spring water may be collected either from the spring orifice or from the offset boreholes. The respondents' tunnels and boreholes were constructed to protect the spring water from surface impacts. The PODs are adjacent to or in the vicinity of natural channels. Spring water flows naturally by gravity from the springs and the boreholes. No pumping or external force is used. Conveyance pipes have been installed to collect water from the spring tunnels and boreholes. Valves along the conveyance pipes control the flow into the collection system. For all the spring tunnels and boreholes, we have diversion data going back to 1947, but no data from before the respondent modified the springs. Please keep in mind that flows that can be measured today from the spring tunnels and boreholes do not represent natural unmodified flow. Therefore, the natural flow of the unmodified springs may have been greater than or lesser than the flow now observable from the spring tunnels and boreholes. Next slide. How do we know springs 1, 2, 3, 7, and 8 are tributary to streams? We saw evidence in the field, and topographic maps indicate they are tributary to streams. Hydrology reports by the hydrodynamics group state that these springs are in or adjacent to tributary ravines, and the Dames and Moore report describes the topography near the springs as containing steep slope stream channels. Also, according to a copy of the 1931 case, Del Rosa Mutual Water Company versus Carpenter, provided by the respondent, California Consolidated Water Company, or CCWC, developed the springs at the headwaters of Strawberry Creek and diverted that water. The Del Rosa case recognized CCWC's pre-1914 surface water rights, and the respondent claims it is the successor to CCWC. Tomas Eggers will discuss this case further in his presentation. Next slide. This chart summarizes the technical and field information we considered when determining if the respondent's spring diversions from its points of diversion required a water right permit from the State Water Board. The criteria we applied were, is the respondent's spring diversion at a natural spring orifice, or was it at an offset borehole associated with a natural spring orifice? Is the spring source adjacent to a natural channel? Does the diversion facility capture natural flow of the associated spring source or dewatered nearby springs? I will next present information about each of the respondents' points of diversion. Next slide, please. Spring tunnels 2 and 3 were built at the natural spring orifices and capture natural flow from springs 2 and 3 respectively, and those springs are adjacent to a natural channel. The respondent diverts all water emerging from the spring tunnels. Therefore, diversions from spring tunnels 2 and 3 are presumptively within the permitting authority of the board. The photo on the left shows the exterior of the spring tunnel 2 vault taken during the June 2016 site visit, but was not used in the ROIs. The photo on the right shows the interior of the tunnel, also taken during the site visit. Spring Tunnel 2 was constructed in 1932 at the natural orifice of Spring 2. Ms. Stork and I observed the interior during our site visit. Spring water seeps out through the walls and floor of the tunnel and pools up behind a small embankment near the exit of the tunnel. Next slide. The photo on the left on this slide shows an aerial view of Spring Tunnel 3 that we took from the helicopter during the June 2016 site visit. It shows the vault and pipelines leaving the tunnel. The photo on the right is from a report from the hydrodynamics group, which shows that the interior and operation of Spring Tunnel 3 is very similar to that of Spring Tunnel 2. Spring Tunnel 3 was constructed in 1931 at the natural orifice of Spring 3. Next slide. This slide shows aerial photos we took from the helicopter showing the tributary natural channel that Spring 2 and 3 would have discharged into. The photo on the left is photo 373 of the 2021 ROI Appendix D, evidence for channels. The red arrow points to the Spring Tunnel 2 vault, and the green arrow points to the Spring Tunnel 3 vault. The photo on the right is photo 372, also from Appendix D of the ROI. The red arrow points to the Spring Tunnel 2 vault, and the purple arrow points to the Spring Tunnel 3 vault in the tributary channel that Springs 2 and 3 would have discharged natural flow into. Next slide. I will now discuss the Spring 7 complex, which consists of Spring Tunnel 7 and 4 boreholes. Spring 7 was adjacent to a natural surface channel, and water from the spring would have flowed to the natural surface channel. According to the hydrodynamics group, the respondent first developed Spring 7 by constructing Spring Tunnel 7 horizontally into the mountain at the spring orifice in 1933. The respondent diverts all water emerging from Spring Tunnel 7, including natural flow. Therefore, diversions from Spring Tunnel 7 are presumptively within the permitting authority of the board. The photo on the left of this slide is figure 1-8 from the Dames and Moore report and shows the entrance to Spring Tunnel 7. The photo on the right is from plate 4 of the hydrodynamics group report, exhibit PT43, and shows the interior of Spring Tunnel 7. The Dames and Moore report indicates that a fault runs through the small round room at the end of Spring Tunnel 7. That fault is identified as the zone of spring seepage, locally known as the Rim Forest Fault. Next slide. In 1950, the respondent constructed boreholes down gradient from Spring Tunnel 7 to intercept the Spring Tunnel 7 flows. These boreholes were replaced in the 1990s by new boreholes 7, 7A, 7B, and 7C, located about 40 feet down gradient from Spring Tunnel 7. The respondent no longer actively diverts or uses water directly from Spring Tunnel 7. The respondent instead diverts from the 4 boreholes, but the respondent could resume diverting from Spring Tunnel 7. At least 48% of the flows from these boreholes require a water right permit because limited available flow data indicate that that portion of the diversion from the boreholes would flow out of Spring Tunnel 7 if not diverted through the boreholes. However, additional information is necessary. This is photo 1 from the 2021 ROI, which shows the concrete vault enclosure for the 4 boreholes at Spring 7. During the inspection, Ms. Stork and I observed the interior of the vault. We observed the pipes, control valves, and flow meters for the boreholes. Next slide. This slide shows photo 347 in Appendix D, evidence for channels of the 2021 ROI. This is an aerial photo taken from the helicopter showing the natural channel that Spring 7 would have discharged into. The red arrow points to the Spring 7 complex. Next slide. I will now discuss the group of boreholes associated with Springs 1 and 8. The original boreholes 1 and 8 were installed at the natural spring orifices of Springs 1 and 8, and those springs are adjacent to a natural channel. New boreholes 1 and 8 were installed offset from the original boreholes to capture the flows from Springs 1 and 8, and the original boreholes were then plugged. Therefore, diversions from boreholes 1 and 8 are presumptively within the permitting authority of the board. Borehole 1A was installed between new boreholes 1 and 8. Available information indicate that diversions at borehole 1 directly affect diversion flows at new borehole 8. Therefore, diversions from borehole 1A are also presumptively within the permitting authority of the board. This photo is figure 1-7 from the Dames and Moore report. It shows the outside of the concrete vault containing boreholes 1, 1A, and 8. We observed the pipes and valves for the 3 boreholes in the interior of the vault during the site inspection. Next slide. This slide shows photo 14 from the 2021 ROI, which shows a view down the watershed from the borehole vault, which we took during the June 2016 site visit. You can see the natural channel or topographic drainage that springs 1 and 8 would have discharged to. Based on figure 1-1 of the Dames and Moore report, the vault is 15 feet from a natural channel. Next slide. I will now discuss boreholes 10, 11, and 12. Boreholes 10, 11, and 12 are associated with springs 10, 11, and 12, but are not installed at the natural spring orifices. Lacking conclusive information that the flows from these boreholes diverted flows from springs tributary to a stream, we treated the water collected from these boreholes as likely all percolating groundwater, not within the board's permitting authority, up to 100%. The photo on the left of this is, the photo on the left is photo 4 from the 2021 ROI, taken during the June 2016 site visit. It shows the location where boreholes 11 and 12 are buried. The photo on the right was also taken during the June 2016 site visit, but had not been used in the 2021 ROI. It shows the backside of the borehole 10 vault. Ms. Stork and I did not observe springs 10, 11, or 12, and did not observe any spring flows in this area, except within the channel of the west branch of Strawberry Creek, a short distance down gradient from the borehole 10 vault. And next slide. While the respondent may be able to claim a valid basis of right to some water from the Strawberry Creek watershed, as will be discussed by Tomas Eggers next, a significant portion of the water currently diverted by the respondent appears to be diverted without a valid basis of right. However, the respondent claims it has a right to take all the water in the Strawberry Creek watershed per the Del Rosa judgment. The prosecution team therefore recommends adoption of a cease and desist order. The CDO would require a series of compliance actions that will bring the respondent into compliance. These compliance actions would apply to the respondent and its successors in interest. The draft CDO would require the respondent to immediately cease all unauthorized diversions of water subject to the board's permitting authority. The draft CDO would also require the respondent to submit a report within 180 days demonstrating to the division that they have ceased all unauthorized diversions and show how they comply. Due to limited flow and diversion information that was available to division staff during our investigation, we further recommend requiring the respondent to submit technical reports that would allow the board to more precisely determine the portion of flow from the Spring 7 boreholes and boreholes 10, 11, and 12 that is subject to the board's permitting authority. These reports can be based on studies the respondent has or is conducting under its USFS special use permit. And this concludes my presentation, Mr. Lilly.
All right, thank you, Mr. Vasquez. So we'll proceed with Mr. Eggers to summarize his testimony, and I'll ask my staff, please put up exhibit PT 12. And Mr. Eggers, you already have taken the oath. You may proceed to summarize your testimony. And I am keeping track of the time. Mr. Vasquez took 25 minutes, which leaves you with 20 minutes. If you can, try to complete within those 20 minutes, that will wrap us up right around noon. Okay, so PT 12 is going to appear momentarily on the screen. And you may go ahead and start while you're waiting for it. While they're putting it up, go ahead.
Just checking you can hear me.
I can hear you fine. Please go
Great,
ahead.
Thanks. Good morning. My name is Tomas Eggers. I'm a Water Resources Control Engineer in the Enforcement Section of the Division of Water Rights. My written testimony is offered into evidence as Exhibit PT 10, and my statement of qualifications is Exhibit PT 11. I have taken the oath and I have no changes to make to my testimony. My testimony will cover the following: general water rights concepts we use to analyze the respondent's water rights claims, the history of water usage at the Arrowhead Springs Hotel, quantification of the respondent's pre-1914 water right, and the conveyance of valid water rights to the respondent's predecessor. Next slide. This is a copy of Figure 5 from the report of investigation. It shows the general vicinity of the water rights claims 7 miles north of the city of San Bernardino in San Bernardino County. The magenta outline is the Strawberry Creek watershed, from whence the respondent currently appropriates water. It is a tributary watershed within the East Twin Creek watershed. Magenta dots in the northern section represent the approximate locations of the respondent's points of diversion. The shaded polygons in the southern part of the figure represent individual parcels that were owned by the respondent's predecessor at the time that historical use of water from East Twin Creek began. Next slide.
And I'll just note, thank you, Mr. Eggers. This slide shows East Twin Creek marked where the last one did not. So that answered my question about that, the name of that creek. So please go ahead.
This is a copy of Figure 5 from the report of investigation. This next slide is from Figure 3 of the ROI. It is an aerial view of the upper Strawberry Creek watershed that also depicts features and properties identified in the historical document search, including the line described in the Del Rosa judgment, north of which any and all of the water of all springs situated or obtainable in Strawberry Creek and Canyon was adjudicated as belonging to the respondent's predecessor. Next slide. The location where water is used determines whether a use is riparian or appropriative, and therefore whether the diverter must have an appropriative water right, or if the water is diverted and used under a riparian water right. Since the respondent currently uses diverted water on non-riparian land, it must have an appropriative water right. The State Water Board has no record of a permit or license issued under Division 2 of the Water Code authorizing the respondent to appropriate water from East Twin Creek or its tributaries. Since a spring is part of the stream to which it is tributary, and since the exclusive means of appropriating water from a stream after 1914 is by complying with the provisions of Division 2, the respondent must, therefore, have a pre-1914 appropriative water right for its spring water diversions. During the investigation, and for many years prior to this hearing, the respondent has claimed its collection of water from the springs at the headwaters of Strawberry Creek is lawful because it is a legal successor to the California Consolidated Water Company, CCWC, and therefore holds valid water rights purchased from Arrowhead Springs Company, or ASC, including pre-1914 appropriative rights perfected by its predecessors in interest and confirmed by the judgment in Del Rosa Mutual Water Company v. Carpenter, the Del Rosa judgment. Next slide. On this copy of Figure 6 from the ROI, I have labeled the 3 principal water courses which enter the Arrowhead Springs Hotel property: Hot Creek, Cold Creek, and Strawberry Creek. They are all tributaries or forks of the East Twin Creek. The upper Strawberry Creek springs are located approximately 4 miles upstream of the confluence of Cold Creek and Strawberry Creek. Next slide.
So, Mr. Eggers, excuse me, Ms. Mullen, please go back to the last slide. I'm new here to this whole matter. Can you just clarify the nomenclature? We have Coldwater Creek in that arrow and right next to it, it says East Twin Creek. And I understand it becomes East Twin Creek, or it is East Twin Creek farther down, but what's the right name for that? Or is it sometimes called one and sometimes called the other?
It's a bit of both. It was referred to in many of the historical documents as Cold Creek or Coldwater Creek, and it is distinguished by the temperature, I believe, from Hot Springs Creek or Hot Creek, which is, you can see in the center of that photo, there's an image of an arrowhead on the mountain, just below the ridge line
Okay,
between
but
those two.
it sometimes also is called East Twin Creek at that point.
According to this map.
Okay, thank you. You may proceed. Then Ms. Mullen, please go to slide 6.
Figure 8 from the ROI is a diagram of water diversions agreed upon by the parties to the Del Rosa judgment. Appropriations are shown with red arrows, while sources depicted with blue lines. Near the center of the figure, there are also green arrows that represent riparian diversions by the hotel. Next slide. The Del Rosa judgment could only adjudicate rights existing among the parties at that time. Since all appropriative rights are based on the amount put to beneficial use, the rights adjudicated in the Del Rosa judgment were limited to amounts that had been put to beneficial use at that time. Furthermore, according to paragraph I, quote 1 to the right, the judgment does not, quote, anywise affect, amend, or otherwise impair any contracts now in existence, unquote, between the hotel and the respondent's predecessor, CCWC, relating to the water of East Twin Creek. So, the terms of the Del Rosa judgment essentially acknowledge that it is not the controlling document with respect to the water rights in East Twin Creek watershed. The contracts are. Next slide. The Del Rosa judgment describes the respondent's right to use water as opposed to other parties, but does not contain a complete or valid description of water rights belonging to the respondent. Though the judgment specified quantities, seasons of diversion, and bases of right for other parties to the action, no quantity or season of diversion or basis of right was specified for CCWC's Strawberry Canyon rights. Similarly, while the judgment addressed priority as between the parties, it gave the respondent's predecessor no priority date, and therefore no indication of its priority within the broader water rights framework. Lastly, and perhaps most problematically, the respondent's entitlement purports to include water which had not yet been diverted or put to beneficial use. While some of the omitted parameters, like quantity, season, or priority date, might be determined by investigating the historical water usage, the respondent's predecessors simply cannot have had an existing right to water which had not yet been diverted. Since the Del Rosa judgment does not recognize any independent basis of right, could not create a right, and did not find that CCWC had prescribed an existing right, whatever rights the judgment attributed to the respondent's predecessor were based solely on its contracts with the hotel. Therefore, we needed to independently determine 1, the existence and characteristics of the hotel's water rights, and 2, whether such rights, if they existed, were conveyed to the respondent's predecessor. Next slide. To investigate the hotel's potential pre-1914 claim and any potential expansion of that claim, we combed the available information for evidence of the hotel's historical use of water. We found that until 1909, the hotel's only uses were riparian. In 1857, David Noble Smith discovered the Arrowhead Springs. In 1864, he opened an infirmary, which would later become the Arrowhead Springs Hotel. He was issued a patent on the land in 1882. In 1887, several notices of appropriation were filed to appropriate water from Strawberry Creek and Coldwater Creek for uses associated with the hotel, such as domestic use, irrigation, bathing, medical use. We'll come back to these notices. A fire destroyed the hotel in 1895. The property sat vacant for the next 10 years until Seth Marshall bought the property and rebuilt the hotel. In 1906, the hotel reopened and the owners started bottling water for its rooms and tables in the hotel basement. Next slide. Returning to the 1887 notices of appropriation, the exact points of diversion could not be located, but based on the quarter sections given in the notices, the PODs were all on properties lying in the East Twin Creek watershed above the hotel. The hotel property, consisting of the David Noble Smith, Elder, Royer, and Coulter patents, is contiguous to East Twin Creek and therefore riparian to it and all its tributaries above the hotel. Therefore, water diverted for use at the hotel from locations associated with the hotel's notices of appropriation was only used on riparian land under riparian right and did not perfect any appropriation. This is corroborated by the Supreme Court case Conrad v. Arrowhead Hot Springs Hotel, which recognized the respondent's predecessor's riparian water rights in 1894 and did not recognize any appropriations. No water would have been put to beneficial use between 1895, when fire destroyed the hotel, and 1905, when Seth Marshall purchased the property and rebuilt the hotel. Bottling started in the hotel basement in 1906, but this would have occurred on riparian land and therefore would have been a riparian use. Some question remained, however, whether the hotel may have appropriated any water between 1905 and 1914 for use in hotel operations on non-riparian land. As we will see in the following slides, our investigation found no such evidence and concluded that the prospect of finding any was unlikely. Next slide. In addition to reviewing information submitted by the complainants and respondent, I looked for evidence of non-riparian water use by reviewing historical photographs for evidence of hotel buildings or facilities that may have been located on non-riparian land. The images included in the following slides were taken from PT 127. They contain approximate representations of the hotel property boundaries and are meant only as visual aids to help identify land and facilities within the property boundaries as visible from the perspective seen in the historical photographs. Next slide. The first photograph is a panorama of the road leading to the Arrowhead Springs Hotel circa 1907. The zoomed in box is a view of the land in the immediate vicinity of the hotel. Next slide. Based on the comparison of the respondent's property map and the 1907 panorama, I concluded that all hotel facilities visible in the 1907 panorama were located on land included in the David Noble Smith patent, represented here with green shading. Next slide. I conducted a similar analysis with a 1910 photo by Charles C. Pierce with the same result. Next slide. The original copy of this photo of the hotel property submitted by Amanda Fry was flipped around the vertical axis. This is a corrected version of that photo. Next slide. In the foreground, you can see tennis courts in the main hotel building. On the right, there's a large secondary building and what appears to be an agricultural field. I concluded that all hotel facilities visible in the 1915 photograph, including the agricultural fields, were located on land included in the David Noble Smith patent. Next slide. The last photo, also taken in 1915, depicts the northern parts of the property which were not visible in the previous photographs. All hotel facilities appear to be located within the riparian David Noble Smith patent. Next slide. For comparison of scale, here's a photo of the old Arrowhead factory from the cover page of the respondent's first response to the 2017 report of investigation. This is the factory where the only water we have determined was being appropriated, as of 1914, was used. Next slide. The earliest known appropriation, that is, water that was actually diverted and used on non-riparian land, occurred in 1909. That year, the Arrowhead Hot Springs Company, which I'll refer to as the hotel, entered into a 10-year contract with the Arrowhead Spring Water Company, a similarly named but completely separate water bottling company, which I'll refer to as the bottler. Under the 1909 contract, the hotel would deliver enough water from Cold Creek to fill 4 of the bottler's train cars a week for the first 3 years and 7 train cars a week for the remaining 7 years. Each tank car had a 6,500 gallon capacity and would deliver the water to the bottler's facility in Los Angeles to be bottled and sold as drinking water. That equates to 7.26 acre-feet per year. Since the place of use was not riparian, the water was to be appropriated. Based on an exclusivity provision in the 1909 contract and information from the 1910 and 1912 litigation, the respondent was appropriating no other water for bottling purposes. Therefore, we determined that the plan of development outlined in the 1909 contract created an incipient water right for up to 7.26 acre-feet per year. Perfection of this incipient right began with deliveries to the bottler in mid-1909 and was completed whenever at least 7.26 acre-feet had been used at facilities later constructed by the hotel. Next slide. In 1912, the hotel decided to build its own bottling plant, the old Arrowhead factory, on a parcel of land adjacent to the Arrowhead Springs Hotel. Based on contemporaneous reporting, it opened around June 1913 at the earliest. We have conflicting information about whether the parcel where the factory was located was riparian to East Twin Creek. But even if it was not, the factory was small and likely only bottled up to 7 acre-feet per year, less than the 7.26 acre-feet per year contemplated under the 1909 contract. Since the hotel did not construct the old Arrowhead factory until 1913, after termination of the 1909 contract and after winning a restraining order against the former bottler, the old Arrowhead factory was not in operation while water was being diverted under the 1909 contract. Therefore, operation of the old Arrowhead factory would only have required continued diversion under that same pre-1914 water right. Next slide. According to the respondent, the hotel's Los Angeles bottling plant, today located at 1566 East Washington Street, was completed in 1917, and its production expanded its predecessor's pre-1914 appropriation. Post-1914 expansion of a pre-1914 water right beyond the amount first used is possible under the doctrine of progressive development if the expansion is within the scope of the pre-1914 plan of development. Based on the available information, however, the 1917 factory was not planned or conceived prior to 1914. Reporting from 1916 indicates that the decision to build the 1917 factory in Los Angeles rather than on the Arrowhead Springs property was made just months before the property was purchased in November of 1916. In February and then April of 1917, the city of Los Angeles issued building permits for what would become the factory. Newspapers reported that the bottling plant was complete and ready to open September 23, 1917. This information corroborates information the respondent provided, but does not indicate the plant was planned anytime before 1916. On the contrary, all the available evidence indicates that the 1917 factory was not planned or conceived before 1916. Too late for an expansion of the pre-1914 plan of development. Therefore, the hotel's only perfected pre-1914 water right was for 7.26 acre-feet with a priority date of 1909. Next slide. Now we come to the question of whether the contracts actually conveyed the hotel's pre-1914 appropriative right to the respondent's predecessor. We know that shortly before 1929, the hotel company, by then known as the Arrowhead Springs Company, or ASC, sold its water department and water business to the respondent's predecessor, the California Consolidated Water Company, or CCWC. There was, however, significant controversy regarding the nature and quantity of water that may have been conveyed to CCWC, including allegations that ASC had made, quote, certain false and fraudulent representations, unquote. The controversy resulted in a notable progression in the characteristics of the rights that were exchanged over the course of the contracts. It was not fully resolved until the final contract made on September 26, 1931, just 1 month before the Del Rosa judgment. The contracts are complicated, but in short, CCWC ended up with the exclusive right to develop water in Strawberry Canyon north of the Del Rosa line, ownership of 80% of water so developed or to be developed, and the right to use 1 miner's inch of water from a hot spring on the hotel property. It is unclear from the contracts what rights ASC retained, but in the Del Rosa judgment, CCWC stipulated to the fact that ASC still owned, after the contracts, the right to divert water for non-riparian uses, including the production of bottled water. In light of the prospective and ambiguous nature of ASC granting CCWC ownership of water that had not yet been developed, the fact that ASC never identified the bases of the rights it owned or sold, the history of alleged false and fraudulent representations, and the fact that all ASC's grants were made without warranty, and in spite of CCWC's stipulation that ASC still owned appropriative rights for bottling water, it is only by an extremely generous interpretation of the contracts that we concluded ASC granted up to 100% of its existing appropriative rights to the respondent's predecessor. Next slide. To summarize, the respondent has long held that its collection of water from the upper Strawberry Canyon Springs is authorized by water rights identified and confirmed in the Del Rosa judgment. In the Del Rosa case, the respondent's predecessor stipulated to the fact that it was, quote, engaged in the business of diverting water from East Twin Creek, that it had, quote, entered in upon springs and diverted from said springs. Nevertheless, the judgment left the respondent's predecessor's rights in Strawberry Canyon undefined with respect to their basis, quantity, season of diversion, and priority, all critical parameters for any valid water rights determination. More importantly, in paragraph I, the judgment explicitly stated it did not affect, amend, or impair contracts between the respondent's predecessor and ASC. In other words, whatever the judgment found, it did not override the 1929 to 1931 contracts. Based on our review of the available information, the only appropriative water right ASC could have conveyed through said contracts, that is, the only identifiable appropriative right there is any evidence ASC owned, was for 7.26 acre-feet per year from East Twin Creek with a priority date of 1909. Therefore, the respondent is authorized to divert no more than 7.26 acre-feet per year of water, otherwise subject to the board's permitting authority from the East Twin Creek watershed, including from the upper Strawberry Canyon Springs. The available information shows that the respondent has diverted far more than 7.26 acre-feet per year of water subject to the board's permitting authority almost every year since 1947, averaging about 150 acre-feet per year over the last decade. That concludes my presentation.
All right, thank you, Mr. Eggers. And we will now, before we take a break, I just want to discuss how we're going to proceed. I will proceed first with cross-examination by Mr. Donlin or whichever other attorney from BlueTriton they select to conduct cross-examination. And then after that, I will ask the other parties who wants to conduct a cross-examination, and I will determine an appropriate order for that. I want to remind parties who are not attorneys, that cross-examination is a time when you may ask a witness questions about the witness's testimony. It's not the time to offer your own testimony. That, of course, you will have an opportunity to do that later. So it's not really a time to argue with a witness about whether or not you agree with his testimony. It's just a time to ask questions. So please keep that in mind as you are preparing any cross-examination questions that you may have. So I have 12:06 p.m. I know we've covered a lot this morning, so I'm going to give us a little more than an hour. We have till 1:15. We will reconvene. My staff has advised me, and I do see your hand, Mr. Brady. I will ask you, call on you before I sign off. But please, at this point, when we do take our noon break, everybody needs to sign off and then log back in a few minutes before 1:15. That we have a separate recording session the way our YouTube and Zoom work. So you'll need to log off and then log back in. Okay, Ms. Grady, question.
I just had one quick housekeeping question, and it's about impeachment exhibits. We didn't talk about how to handle that. Do you have a preference?
Okay, thank you. Do you have new exhibits that you want to ask these witnesses as part of your cross-examination?
I believe my colleagues do have some exhibits they'd like to use.
Okay, Mr. Donlin or Mr. Sanders, how many exhibits are we talking about here?
If I'm not mistaken, Mr. Lilly, we have about maybe a dozen.
Okay. The best way to do this would be if you could submit those. I'll have Mr. Anderson will speak up if I get, or Mr. Wooldridge will speak up if I get this wrong. But I think the best way to do this is for you to upload those to this FTP site in the same folder that you uploaded your prior exhibits for BlueTriton brands, and to number them sequentially after your last exhibit. I think your last exhibit was BTB 15. Is that correct?
We already have them identified, numbered, and we extended our numbering system. We have a couple of breaks in between, but yes, we're intending to just continue on with the numbering system already established.
Okay, so I'll ask you to upload those now. I know that there's some question you don't want to release them before you conduct your cross-examination, but frankly, I think an hour's time is not going to be a problem here. So I ask you to upload those now, and then we will move them over to the BlueTriton exhibit folder, because these are BlueTriton exhibits with the numbering. At some point, we will update our exhibit list. And then when whichever attorney wants to do the cross-examination may ask our staff to post those on the screen for that cross-examination. And of course, any party may object if they think in any of the cross-examination questions using any of these exhibits is improper. So, Mr. Petrozelli, your question, your hand is up.
Yeah, I'd like to object to the use of surprise impeachment evidence at this time. Even though the APA Government Code Section 11513 allows for impeachment, the board regulations specifically state that it is the policy of the board to discourage surprise testimony and exhibits. That's more specific than the APA. In my experience in hearings, the board has always required these types of exhibits to be submitted with the case in chief or with rebuttal. When I've been presenting cases, if I tried to present anything that I hadn't included in my case in chief exhibits, I was always told, you missed it with your case in chief. You can't present it now. You can save it for your rebuttal if that's what you want to do. And I believe that's what we should do here. The respondent had the same deadline, December 17th, that the rest of us did. It had a subsequent deadline up to December 31 to submit other evidence. So they had ample opportunity. They've complained at length about surprise evidence and due process. So I'm surprised they're attempting this now.
Okay, Ms. Doty, your hand was up. Do you have anything you want to add?
I was going to ask a question about the procedure for objecting, which I believe you addressed with, we can step in to object. But I think that Mr. Petrozelli's question is important, and we would like also second the request to be able to observe the exhibits beforehand. We noted that BlueTriton removed their water rights person and I think it was a geologist that they had originally had on their notice of intent to appear. So they have apparently made the strategic decision to wait until rebuttal. And it seems quite unfair, given their objections again this morning, that they should be able to spring that on the rest of us with 1 hour to review and try to understand whatever it is in these up to 12 exhibits that they're going to use.
All right. I'm going to just ask whichever BlueTriton attorney wants to address this. I don't remember, did either we had 2 pre-hearing conferences. Did either of those or the notice of hearing specifically address the question of how exhibits for impeachment purposes, exhibits to be used in connection with cross-examination questions would be handled? I just don't remember. Does any of the 3 of you remember about that? And then also, yeah, go ahead, Mr. Sanders.
Yes, we actually did raise this issue. I don't remember exactly which pre-hearing conference it was raised at. We raised the issue that we were going to introduce impeachment exhibits, and you indicated that those impeachment exhibits could be brought in at the time that the testimony is presented by the opposing party that we wanted to impeach.
All right, that seems to be my recollection too. Ms. Doty, do you want to say something, or your hand's sort of half up? Can't tell if you want to say something or not.
I'm a little mystified because, again, it's pretty unusual in this situation because BlueTriton Brands was given that extra opportunity with regard to the testimony of the prosecution team to submit new evidence by the 30th, I believe, of December. And so, and because the testimony has to be entirely written ahead of time, they have been on notice this entire time about what that is. So the only reason to delay submitting exhibits beyond the 30th would be to take advantage of surprise. They had no surprise. They were given the testimony.
All right, Mr. Petrozelli, anything else? Let's try not to belabor this, please, but go ahead.
Yeah, this issue was discussed in the pre-hearing conference. It was not discussed in the order following the conference.
Okay, that I believe that is correct. And I haven't gone, Ms. Ray, I don't think you're going to need to speak based on what I'm going to say, but if you still want to after I'm done saying it, go ahead. I do recall vaguely, I'd have to check my notes or the recording, but I do recall talking about this. I believe I advised the parties that they may offer exhibits that they may use in connection with cross-examination. These really are not exhibits that are part of a party's case in chief. They're for cross-examination of another party. So I'm going to allow this process to go forward. I do ask that Mr. Sanders, you or one of your colleagues, get those to us as soon as we can, so we can get them posted as soon as we can. And Mr. Petrozelli, if you or one of your witnesses states in response to a cross-examination question involving one of these impeachment exhibits that you need more time to review it, then you or one of your witnesses may so state, and we will, I will determine whether or not more time is appropriate. I do understand your concern about being blindsided with a new exhibit. The witness may or may not be able to testify about it. It's going to depend on whether the witness has seen the exhibit before, how long it is, and so forth. So let's proceed that way. I'm going to allow them to upload them. Again, we're not admitting them into evidence yet. I'm going to allow them to ask questions, but then you may object if you think that your witnesses need more time to respond. So with that, is there anything we have to cover now, or can we come back at 1:15? All right, remember, everybody log off and log on just a few minutes again before 1:15, and we will come back then. Thank you.